Welcome, my little couch potatoes, to the comfiest courtroom on the internet. I'm your host, Lama, and it's time for dramatic testimony, overruled objections, and absolutely unqualified opinions. So grab your snuggiest blanket, some delicious snacks, and get ready to watch court with your internet besties. This is Couch Court with Lama.
Bring the jury.
Hello, friends. Happy Fu Kong Friday.
It is
We
Fu
made
Kong Friday.
it is Fu Kong Friday. It's our favorite day of the week, I think.
Oh, it's been a
You never
week.
know. It has been a week. You never know how Fu Kong Friday is gonna go. Are there gonna be surprises? Is Lana gonna get day drunk because she can't handle David Gingras' dumbass things he says? What's gonna happen? You never know with Fu Kong Friday. But before we get into it, let's say hello to our chat. Hello, Christine Fortunato. I knew that's what it was. But in fairness, I just woke up not that long ago. So, and I only woke up not that long ago because Wallace Juno was in a chat with me last night. We were on Hellville's, excuse me, channel because she had listened into the Owens meeting of creditors for their bankruptcy case, right? And so she was doing her best trying to read the notes, but chat was a little wild and we derailed a lot of conversations. But it was a fun time. And then she's actually going to be doing part 2 later tonight. I think I want to say 6 p.m. maybe. So that's where we were partying pretty late last night. But good morning, Wallace. Happy to
Well,
see
I
you
wasn't
here.
invited to the party. No, I'm just kidding.
Were you tardy to the party?
No, I was crashed
Okay.
out. I was emotionally drained from yesterday. So I went to bed.
Here's Wings. She's so pumped up. She's so pumped up. And I'll tell you why here shortly. Hello, Bella's mom. Good morning to you. Razmataz. Good morning, babes. Hope you're doing well today. Bruce the Moose. Are you staying inside? Because so the north has this huge wildfire that's happening. And like last night, it wasn't really that bad for us down here, or yesterday, it wasn't that bad for us down here. It's like covering like all of Wisconsin, Michigan, Indiana, Ohio. And like, so like we're like northern Ohio, like Cleveland, like you couldn't see the city. It was all smoke,
Wow,
all
that's
smoke. And
crazy.
so down here, like it wasn't that bad. And then when I got done with True Crime and Wine Time last night, I went outside to let my dogs out and like it smelled like smoke really bad because Amos was like, yeah, it's pretty bad outside because she's, in Michigan. And so then it started to get really heavy. And I was like, oh, that's why I don't really feel that good. Because we had it like happen 2 years ago, I think it was. Oh, it was not a good time.
Insane.
It's not a good time. So hopefully you get to stay inside all day, Bruce. My elbow feet, his job called everybody off work today because he works outside. And they were like, no, sorry, nobody's working today. So for anyone that is by the fires themselves, I do hope you are safe. Anyone in the direction, it's so much smoke. It's unbelievable, which makes me so sad because
Hmm.
then in order to have that amount of smoke go across multiple states at one time means like we're losing a
Oh,
lot of
yeah.
forest, I'm like, that's so sad. But, if you have any breathing problems, anything like that, and you live in this area, do not go outside. Okay? Do your best. Do your best to try not to go outside because that smoke can get you. Just like, or at least, maybe wear like a mask or something because it's pretty heavy out there. So I hope you're doing well, Bruce, and my Wisconsin, Michigan, Indiana, and Ohio friends. Hello, Say Cheese. Yeah.
Words.
Happy Fukong Friday to you, babes. Hope you're doing well today. April, good morning. No thanks. Okay. Good morning, babes. She was partying with us last night, both her and Say Cheese. It was a wild, wild night. And Becca, good morning to you. Amos, good morning. So well hidden. Hello. Good morning to you. Happy Fukong Friday. Happy to see you here. Nord, look at you. Yeah, you're finally here for the start of it. I know last night for True Crime Wine Time, you're like, duh, I was late again. So happy to have you here today. And she's, yes, I do have a surprise for you guys. It's so good. It's so good. Good morning to you, Sheeves. Echoes. Good morning to you, good sir. Hope you're doing well. Hello, LMP. Hello. You have at least 3 different air filters running. Good. Good. I'm glad that you get to work inside and stuff like that. So that's great. You glad found someone oh no, I didn't join her. I didn't go on Hellville stream last night. I was tired. You know how many streams I did yesterday? Nah, I was all sitting here, my PJs, watching somebody else for once. Maybe tonight if she's not doing anything. I don't know. See, it's Friday. It's Fukong Friday. Anything can happen. Cracked pepper. Good morning. The haze. Oh, yeah. I guess Pennsylvania would be getting it too soon, huh? Yeah, it's thick. It's thick. I was like, Amy, I don't know what you're talking about. And she said to me yesterday, and then I was like, okay, Amy, I know what you're talking about. Also, I just put coffee all over my arm, so that's a great way. Hello, Deb and Savage. Good morning to you guys. It is awful. It is very awful. So, everybody stay safe with that. Hi, Boots and Ms. Wings. Good morning. Look at everybody on the couch today. I love that. You guys have the Saharan dust moving in. Oh, that's like just as bad, I would imagine. Right?
Mhm.
Yeah. Oh my
Can
goodness.
be.
Oh my goodness. Teresia, good morning to you. Or Teresa. Sorry, there's also a Teresia in chat. But Teresa, good morning to you, babe. And Angie, happy to see you here this morning. Yes, guys, if you haven't while you're coming in, please hit the like button. If you're new, subscribe, hit the notification bell so that way you never miss when we go live or drop an episode. And in case you haven't been paying attention or you've been very busy because it is summer and people are very busy. I also, so Couch Court with Llama does have its own channel now at Couch Court with Llama. And eventually this show will be moving over there permanently. So make sure you go over, subscribe there. If you could watch the videos that are over there, which includes our bricks and minifigs coverage. We have how many? 6 now? Because we just watched yesterday, something like that. And if you could just like watch them, that would be great because like we need the watch hours and stuff. You can put them on mute. I won't tell anybody or be offended by that. But if you can go over there and give us a sub as well. Hello, Malin. Good morning. Well, oh, good evening to you. You must be in a different place. So good evening to you then. Jen, hello, hello. I hope it's not the audio from yesterday. Not yet, Jen. Oh, I forgot. You guys might be thinking that's what that is. It's not. And I'm sorry. Your hopes up. Maybe that'll come in later tonight. If it does come out, we'll be streaming this weekend if that's the case. If it does come out today, but if it does, it won't be till like way later tonight, probably. What, like 6 maybe? 7. So we'll see. It is not that, and I'm sorry. But it's real good because it's in this box. So chat, why don't you guess? So Wednesday, I was having a really stupid, shitty day because people are dumb. And I went out to let my dogs out. Who let the dogs out, Savage? I did. And on my porch was this lovely package. Make sure I'm doing it the right way. And I was like, what is this? Because Terry, True Crime, was sending me something and I had already gotten that. I was like, what is this? And so I picked it up and I saw the return address and squealed. That's what happened. And so what do you think would be in this box that is Laura Owens related? That Llama was like, oh my.
Well, I can't answer that because I already know
You
what's in the
can't.
box.
What's in the box?
I
What's in the
know.
box? So, what do you guys think it is? Hello, Peach Teach. Hope you're doing well today. Barbecue Queen. Hello, little ducky. Mama Bear. Mama Bear knows what's in it.
Is it a
Yeah.
pony?
Is it a pony? It is not a pony. It is not a pony, but it's way better than a pony.
I think it costs
Way
as much as a
better.
pony.
Oh, you were kidding about the thing. I wish if we had that, we'd be watching that right now for sure. I heard it's wild. The few bits and pieces I heard last because I was late to Hellville stream. I was just like, oh, they said what in federal court? Are you kidding me? Are you kidding me? So, oh, you're in Sweden, Malin. That's pretty cool. Oh, so is Nick. I love that. It is not a pony. No, no, no. It's not a pony. P Master 5000. No. HCG. No, no, it's not. Hold on, let me.
It's a
Well,
moon
first,
bump. No,
it's
that's a very small moon bump.
no,
Unless
I
it inflates.
well, before I open this though, in case you guys didn't know, so you know how Laura Owens like copyright striked our outtakes video that we did of our TEDx talk, like because she was like, no, I don't like it. Um, anyway, she never filed papers in federal court, so we won, and that video is now up on our True Crime and Wine Time channel. So if you didn't get to watch the outtakes, it is a green, very noticeably green thumbnail with unflattering screenshots of her from the outtakes, but it's up. She can't get it taken down again. So please go watch that a bunch because she apparently did not want people to see that. And therefore, I think that just means we need everybody to see it. So if you missed when we did that, when was that? Like the Thursday after the fundraiser, I think. It's been shut up that long. And so now it's not like going to get put back in the algorithm or anything. So if you guys can like go watch it, share it, put it on your social medias, that'd be really great. And she wouldn't like it. So, that's great. Is it a House of Prime Rib gift certificate, a membership to Barry's? One of those devices. No, but your guys' guess is hilarious. No, it's none of those things. Oh my God. Sorry, you'll know why I just did that in a second. Are we having twins? No, we're not having twins. No, let's see. What should I do?
But I did get a little pregnant after I found out what it was.
An AOL disc.
Oh my gosh, I remember those.
Right? Okay.
When the internet came on a CD-ROM.
So I didn't know that this was coming to me at all. So when what's the best way to tell you guys this? Well, I know the best way to tell you this. I'm going to tell you whose name was on the return to sender. Okay. So I pick up this box outside and I'm like, who's this for? What's this? This is weird. And I see it has my name on it. And I was like, oh, that's weird. I already got a box literally the same size from Terry. And I was like, okay. And so I looked at the return sender and I said, oh my fucking God, why do I have a package from Omar Serrato on my porch right now? What is happening? How does he even know my address? What's in the box? What is happening? Why did Omar send me something? And I was like, what? What is it? What is it? You guys want to know what it is? Well, I am going to tell you what it is. It is what Omar is known for the most. And that would be his red tie from Mike Marraccini's, DVR trial that didn't happen. But it's the tie. It's the tie. It is. And oh my God, you guys, he smells. It's intoxicating. It is that oh wow earlier was because I opened the box and it's just the pheromones are just like, oh my God. No, it smells amazing. Yes. So now he also sent it's soaked with Laura's tears. Oh my gosh.
I'm
it's
muted.
amazing. You're muted.
I asked if you
course
were are you pregnant now?
Maybe. No, it's amazing. So I get to wear his tie all day today. And I have it. This is the first time I put it on too. So I've been sitting on this since Wednesday because normally on Thursdays we cover bricks and minifigs. And I didn't want to not let you guys know the news. So don't worry, I'm about to tell you who won the auction. So I was like, oh my God. Right. And so I know who won this auction, and the person that won this auction was Winks. Winks won the auction for the tie. All right. And I was like, oh my God. This tie got a bid of $1,000 during the fundraiser. And Winks, because she really is the sweetest, nicest person in the world, had him send it to me, which was beyond kind. I did not ask for it. I did not even think about it. It wasn't even on my radar that that she would have him send it to me. Well, yes, Mama Bear did win. Well, she did the bidding, but Winks was Winks was bidding. So it was so incredibly kind of her to have Omar send me this because I was having a really shitty day, and I was like, thanks, Winks, for making it better. So he also wrote her a really lovely note. To Winks. I think he was getting ready to ship it, and she might have been like, yeah, so I'm going to need you to send that to Llama. But don't worry, I'm gonna mail this letter to her because I have a letter. I also have, maybe I'll just put these in a Ziploc bag, these like 4 tissues that smell exactly how you think they would smell. And maybe we'll auction those off for the next auction. How much can I get for 1 tissue for Mike Marraccini that smells like Omar? Which, by the way, the QR code still leads to his GoFundMe. Anyway, so Omar wrote this to Winks, and she told me it was okay to share with you guys, and it's incredibly kind, and I think everyone needs to hear this. So he says to Winks, Winks, I'm still absolutely flabbergasted that you paid $1,000 for this tie that has been in my life for roughly 5 years. I know it wasn't about the tie, it was about the cause, and to that regard, I'm genuinely touched by your kindness. When I offered the tie, I hoped it might raise a little something for Mike, and I never imagined it would find its way to someone so willing to give. Thank you to everyone in the community who made this possible, and mostly thank you to you. Most, sorry, it's kind of in his lawyer handwriting, but I think it's mostly thank you for everything you've done and everything you do. I hope the tie brings you every bit of joy you could possibly hope for. With sincere gratitude, Omar. Like, look at how cute that is. That's so cute. He has such fancy handwriting. Um, and so I guess Winks had him send it to me, which is so incredibly kind. I I can't even tell you how lovely and nice that is. But Winks did so much for that fundraiser. I said it then and I said it now. Like, that fundraiser took a lot of people to make that fundraiser happen. And so now I'll bottle up the scent. No, just kidding. I am gonna mail this out to Winks because she definitely deserves this letter. And he's absolutely right. I know he was just as shocked that his tie went for that much money. But yeah, so look at that. Oh my gosh. That's also why I'm dressed kind of fancy today. Because I was like, oh, I got to play the part of Omar. So, oh my God, it smells so good, you guys. It's ridiculous. I don't even know what cologne does he use because I'm going to need to buy that for elbow feet. I don't know perfumes to give any idea of what it must be, but yeah, you don't remember dragging your book through any cologne. Yes, yes. Thank you, guys.
Apparently it's a thing, Bruce. You need to get on that train. We pay extra for the cologne soaked books.
Right? And then who knows? Maybe someday later we can clone Omar. I'm just kidding. I don't believe in cloning. That
That's
doesn't go
weird.
well. That's weird. That's weird. Don't be
That's
weird,
weird.
Mama. Don't be weird. So yeah, it's a really nice tie. I don't even know what brand it is. Pronto Umo. God, it smells so good. I can't even. I'm distracted, guys. I'm distracted. But it's so delicious. um, Again, thank you so much, Winks, for sending it to me. She really is like the best. And I really, really do appreciate it. I don't I don't know if I'm the one that should have it, but I do. And that's amazing. It's just so amazing. Because it's still like wild, right? That we were able to pull all of that off. And I don't know. It's really nice to see the goodness of people sometimes, because sometimes we get lost in all the other stuff. And kindness goes a long way. And you know what kindness is? It's free. Well, I guess not free if you bought a tie for a fundraiser. That probably is not free. But you know what I mean. um, but yeah, thank you so much, Winks. I really, really appreciate it. um okay, so we have that going. Oh my God, there's so many comments, but that's okay. Oh, thank you. Yes, we got it back. We got it back. So suck on that, Laura. But it seems that she was busy filing uh stuff with Mike this week. So I guess, priorities, huh? Yeah. She filed stuff that when the 13th, I think, in that we haven't got it yet. But it was like asking for the correction of the record, augment the record. And then she had some documents in her criminal case. So we'll see. We'll see. It was an amazing day. I know. I know. We were so funny about Omar. Excited about this tie and the smell. Y'all, if you could smell it, you would see why. My face is gonna hurt because it's just over here being like, oh my goodness. Oh my goodness. Um, yeah, right. You'd make a copy of the note. Oh, I am. I do have a scanner, so I think I'm gonna do that. And then I think I'm actually gonna like put it in a frame, like or something like that. So that way, one, it keeps it sent forever. But I think that's what I'm gonna end up doing with, and then bring it out maybe for special occasions. Because you never know. This seems to be the story that never wants to end. So the day that Mike is free of this DVRO and a pellet BS, that's a great day. So I'm very excited about that. Now tell them about the sisterhood of the traveling tie, or we mail it to one another. Oh yeah, we can do that. We can mail it to one another. We'll start a list. We'll start a list.
We had an agreement that it was supposed to get sent to
Dang.
each other at a certain
That's
time.
true.
That
That's
everybody was
true.
going to have shared
I
custody of the tie. There
I
was a
kind of forgot about
contract.
that. Right.
We had a
We
front.
did.
We had a contract.
I forgot all about
We
that.
all signed it.
That's true. We did. We did. It's a hilarious contract. Maybe we'll read that some
Don't
other
make me
time.
take you to court
Don't quarter of the time. I did forget about that.
because we need a parenting
So
plan.
we need a
Obviously.
parenting plan for this and everything. Hello, Wendy. Good morning to you. Oh, thank you. Oh, you guys we could have done it without everybody, so it's very amazing. Hello, Bill. Good morning. I am again. We need to know what his cologne is because anybody who people need to wear this. you want yeah. It Oh, you like Stetson black. I thought you were saying this was Stetson black. Well, somebody needs to find out. And everybody either go wear it yourself, get your husband, your boyfriend, your significant other wearing it. They'll thank you probably. They're gonna thank you. Hello, Ivy. Hello, hello, hello. All right. So those were our two big. Yes, it really is a shared custody agreement for the tie. Hold on, I'll find it. We we wrote this after the fundraiser for funsies. I don't know.
Yeah. Yeah. It's probably buried deep in the
That's
piles of
okay.
stuff.
That's all right. I can find it. What was it? Link?
Yes, there's a dating contract for the tie.
There is. Let me find it. God, we talk so much. It's ridiculous.
That's why I told you it's buried deep.
I know it is. Let's see. Well, it would have been around the time of the fundraiser. So this was right after. Oh, found it. Boom. Hold on. I think, is this the first copy? Oh, this must be the final copy. All right. Well, why not? We're just
Yes,
here
there
for
were
fun.
drafts. This is what we're doing. We did drafts of a tie's parent. We have way too much time sometimes for the most ridiculous things.
We do. We do. All right. Yes, that's right. Let's read this. This is great. All right. Let me pull this up. What do we do in our spare time? No, we actually do.
Guys, we're so busy. We write up contracts for ties. Don't ever let her tell you she's so busy. I'm just kidding.
Right. I love having fun when we're busy. It's my favorite thing. So, all right. So here's the agreement we wrote, the real life. We made this when June 14th at 3:04 p.m. So the day after. The Sisterhood of the Traveling Tie, a totally binding, completely enforceable, definitely not made up agreement. June 13th, 2026, entered into on this glorious day by the undersigned members of the Seven Sisters of Serrato Neckwear, hereafter known as the Sisterhood. Preamble. Whereas a legendary 12-hour fundraiser was held in support of Mike Marraccini's ongoing legal battle against Laura Owens, and whereas through the generosity, you guys, determination, sleep deprivation, and questionable auction judgment of the community, an authentic necktie worn by the esteemed Omar Serrato was successfully auctioned, and whereas Mama Bear emerged victorious with a bid of approximately 1,000 United States dollars, thereby becoming the lawful keeper of the tie. No, Mama Bear's winks. Well, they're not the same person, by the way. Let's not confuse the masses. Whereas it has become apparent that no single individual should bear the responsibility of the possessing such power indefinitely. Now, therefore, the parties agree as follows. Article 1, we're such fucking nerds. We're such nerds. Article 1, definition of the tie. The item herein referred to as the tie shall mean one, necktie worn by Omar Serrato, a symbol of justice, friendship, perseverance, and mildly concerning auction competitiveness. Not to be confused with a relic, although several members may treat it as such. A relic it is. A relic it is. Article 2, members of the sisterhood. The following individuals shall be recognized as equal sisters of the tie: Terry, Llama, Amos, Buffy, Winks, Lady in Gray, and Mama Bear. Our fundraiser committee. Collectively referred to as the tie holders. Article 3, custody of the tie. 1, Mama Bear shall be recognized as the original tie mother. 2, the tie may travel between members for fundraisers, couch court appearances, victory celebrations, community events, photo opportunities, and general emotional support. I assure you, you will not be depressed if you smell this tie. 3, no member shall claim sole ownership of the legend, lore, or mystical powers of the tie. 4, the tie shall never be sold, traded, pawned, raffled, or exchanged for Taco Bell. Never. That's a hard no, or you are kicked out of the tie holders. Article 4, duties of the current tie or holder. Good thing we're reviewing this because that's me right now. While in possession of the tie, a member agrees to keep the tie reasonably safe. Speak kindly to the tie. You smell so good, tie. Just so good. Refrain from using the tie as a napkin, a pet toy, a curtain tieback, or a weapon during internet arguments. I don't know. The next one, that one's going to be hard. Post at least one photograph with the tie demonstrating that it remains among the living. Here's your proof of life, everybody. Proof of life. I need to ensure this tie. You're right. I do. Absolutely, Echoes. You go right ahead. Go right ahead and clip it and share it. I don't care. That's fine. Go right ahead. This is all of our tie. This is all of our tie. Now, Article 5, legendary powers of the tie. Possession of the tie grants the temporary holder immunity from at least one internet troll per calendar month. Okay? So take that, trolls. The ability to identify at least 3 contradictions in any Laura Owens filing within 5 minutes. I mean, really, it takes like 30 seconds for the very first sentence of all of those, but still. The sisterhood acknowledges these powers have not been independently verified. Article 6, emergency transfer protocol. Should any sister experience an unexpected rabbit hole, a document dump exceeding 500 pages, excessive eye rolling, a sudden need for moral support, the tie may be overnighted to another sister in need. Article 7, annual gathering of the tie. This is what we should do yearly, I think. We can have the big LO convention and call it the gathering of the tie. Why not? At least once per year, members shall make a reasonable effort to gather virtually or in person to celebrate friendship, remember the fundraiser, tell increasingly exaggerated stories about the tie, and debate whether Omar knows how much lore has developed around his neckwear. He's going to love this. He's going to be like, what did I do? Article 8, Oath of the Sisterhood. Each member shall recite, I solemnly swear to uphold the honor of the tie. I shall protect it from stains, trolls, and bad takes. I shall remember the fundraiser that brought us together, and I shall share custody when called upon. I shall not weaponize the tie in petty disputes, even though I have it. So, no, I'm just kidding. To my sisterhood, just kidding. And should justice prevail, I shall raise a glass to friendship, community, and the fact that somehow a necktie became a legend. Executed this day by Terry, mistress of Going Live and guardian of all pink glitter, Llama, Grand Duchess of Rabbit Holes and Side Eye, Buffy, the sidekick and lady of the raised eyebrow, Amos, the sidekick of the sidekicks and backstage chaos, Winks, mistress of competitive generosity, Lady in Gray, guardian of logic and patron saint of fact checking, and Mama Bear, the keeper of the knot and bearer of the holy polyester. Witnessed by the internet, which will absolutely never let anyone forget that Omar Serrato's tie sold for $1,000. And that's our agreement, you guys. That's what we did the day after the fundraiser. So there's that. You're welcome.
Are
When
you
you work
sure
hard.
Laura didn't write that? That was 4 pages long, or Jingers about a tie.
We had to cover the whole thing. Hold on, let me write an extension for more, a motion for more pages, please. Excuse me. So that now everybody knows about the sisterhood of the traveling tie. So yes, that's what we will be. Oh my God, it smells so good. I have to send stuff to you guys. Like I have to. You guys need to know what this smells like. It's wild. Wild. So anyway, I knew you guys were going to be so excited about it. I've had to sit on this since Wednesday. We were going to go live and I was like, no, let's just wait. It would have been 30. Hey, after hours response. How you doing? It would have been 39 pages that they written. Yeah, right. With a motion to write more, please. But yeah, that it lacks petty personal attacks. Don't worry, there's other documents. That was draft one, I think. No, I don't know if there's other ones or not. I don't remember. Um, but keep it ziplocked to preserve the pheromones. Bet, girl. As I said, how much can we auction off? We have 4 individual tissues. We're gonna save those for the next fundraiser at least.
You have to ship it in those tissues to keep the
Oh yeah, that's
smell.
true. That's true. I don't know. I'm not like a scent.
Okay.
Honest, I don't know. I don't know how those things
You're
work.
not a waft
No
expert.
wafter.
The waft.
No. Oh my God. I don't even know how I'm gonna do anything today. It's intoxicating, you guys. Intoxicating. You would also sit on the tie. Oh, hi, Jupiter Jane. Well, I'm so glad that you guys enjoyed our surprise for today and our weird things we do when we're off screen. We're always working hard, but we're always also goofing off at the same exact time. Because you can't take yourself too seriously. You can't do that. So I'm wearing it with pride, Omar, if you're around, but maybe not yet because you are on the West Coast. So we'll give you more tie updates. Also, you know what? Why don't you guys contribute to the tie lore? Okay. So after this, put it in the comments. We'll start a whole the tie lore book because I love that kind of shit. So we could do that. Yes, the tilted tie needs its own IG
Okay.
account.
So, question, does the tie become like flat Stanley? You know, like when you're in school and like you have moms, y'all know who Flat Stanley is. They give you a cutout and you're supposed to like take this cutout picture dude and take him places and take pictures of him in doing different things. It's a flat
I've
Stanley.
never heard of this.
Yes, and well, your kid goes to like one of those smart kid schools. We're talking about like public school, okay? So they give it to the little kids
Okay.
and you like mail it to like a family member that lives in another state and they take
Okay.
a picture and like of it doing something in that state and then they mail it to someone else. And so like this kid collects Flat Stanley going all over the US in different places and has like presents it to the class. It's called a Flat Stanley. So you could do that with your tie. Take your tie out for like ice cream. Take your tie out for like this and like look at the tie is doing cool things. And then somebody else can take
Actually,
it.
I love that.
And so
I
the
love
tie
that.
has its own life. We're just making it
Oh,
really weird today.
I mean, we are weird. We are so weird, you guys. I've never heard of it, but Jet has. Kimbo has Stanley trauma, flat Stanley trauma, PTSD apparently, and Dana's heard of it.
Yeah.
But yeah, that's oh look, there's a flat Stanley on a West Wing. How do I not know about this? Also, hello, Linguini. Yeah, I've never heard of it either, but I love this idea. I love it. We could vote like where does the tie go next? Oh my gosh. But then I have to like leave my house, which I don't love doing. But I'll do it for you guys and I'll do it for the tie and for the sisterhood oath I took,
Well, the tie needs
a month
lore.
ago.
In order for the tie to get lore, it has to leave the house.
That's true. That's true. Well, I guess I don't have social media at all. So I guess why not start an Insta for the tie? If anyone needs a social media, it's not me. I could just do it for the tie. Take the tie out for pad thai and just like talk to it the whole time. Like, oh my God, you are so funny with your checkers. Love it.
You should set up like a romantic table and have the tie on the chair across from you and a rose.
Oh, I
in the
will
middle,
never come on my
candlelight.
show again.
You'll be dating the tie.
He will never come on.
Forget
He's like,
Omar.
"This
We
is
just want the
weird."
tie.
Is it silk? I don't know. I'll be honest. Like, I don't think so.
It's
Hold on.
probably polyester.
Let me see. Let me see. No, it's 100% silk. Yes.
Oh, damn. Okay. Well, I
100%.
forgot. He's probably in a different tax bracket than I am.
Ignore my fingernails. I need to repaint. Sorry. They were so close to the camera. I wasn't expecting to do that.
Mine come
They're
from
on my to-do
Walmart.
list tomorrow. Um, I bet Bruce the Moose smells well as well. Um, got that woody smoke. Oh no, Mama, just stop saying things. What are you doing? Keep your mouth shut. But yeah, we could totally do something like that. I think that's great. But so there's that. But yeah, 100% silk tie. And the brand, as I said earlier, was Toronto Umo. So I don't know what that company is. I don't know. I don't know. I know Zippy Zap about ties, but all I know is I look good with it. So it does go with his silky voice. I know. I mean, if it was expensive or not, it doesn't even matter. I mean, it got it is expensive tie. It was $1,000 bid by the lovely Winks, who was kind enough to do that. So
We're not tie people. We're white t-shirt people.
Jeep Daddy would like to know how to apply to the sisterhood, please. We're quickly going to become a cult, so
We'll
prepare
take
yourselves to join our cult.
applications.
We will, yeah. We need a recording of it. Oh my gosh, we're all going to get pregnant so quickly. It'll be an epidemic. The tie was spotted simultaneously winning the ring toss and go fish at a local carnival in Mississippi. What's next for our neckwear adventurer? I love it. Tony says, "Oh my God, Jan was constantly bringing up the smear campaign, and it wasn't for them. This the GoFundMe money wouldn't even be without them. It's a very big thing. Yes, whenever that comes out, probably if it comes out later tonight, we're probably covered over the weekend. Because your homegirl is tired, in case you can't tell. Uh, but I do hope it does come out this weekend because I need to hear it with my own ears. Not the smoky wood smell. No, I guess not that one. Though we're all gonna smell like that up north for a while. My goodness. Ugh. Oh gosh. Okay. What are we here to do today? I don't even.
She don't know. That's it. We're going. That was all
If it's Omar's,
that was all she really wanted to talk about.
if it's Omar's, then it's expensive, it's nice, and it's classy because he has all of those things. Also, super fun and down to earth guy, which I love. Because some people are just very arrogant, you know? Nope, not at all. You're just like talking to a regular person, you know, which sometimes is hard to find. But no, he really is incredibly nice. And I know he was just as like surprised about it as well. Like, holy what? I'm just a guy, a lawyer, man. I'm just a lawyer, man. Everybody, yeah, everybody is. Yep. The Thai is our new baby daddy, not Omar. Let's clarify that. No, the Thai. So it's got to go traveling and get a job. How's it going to pay all that child support to all of us? I mean, come on, Ty, get it together. Can I post in Discord? Yeah, I can put it in there. It's just something silly. It's not anything serious, but don't stop talking me up. Oh, wow. Yeah. All right, yeah, hold on. Let me put it in there so I don't forget because it's like that over here, y'all. I'm gonna put it in the Laura Owens chat for our Discord. Or wait, which do you in our Discord or the other? I'll put it in both. I'll put it in the courtyard, and I'll put it in the JFC one. I'm gonna put the sisterhood. What did we name it in the first place? I forget already. The the sisterhood of the traveling Thai contract. Okay, sisterhood of the traveling Thai contract. Oh, that would be really fun. We should do. Upload a file. Oh, that's funny. That's funny, Amy. You're so funny. Okay. There's that one. I don't know where I should have put it in it. That's right. I'll put it in the other server for you guys. I don't know where I should put that. I'm gonna put it in the JFC content, and Winks, you can move it to wherever you want it to go. You're the boss lady, and you can move it to the right spot so I can get back to my show. All right, there we go. Lots of laughs. Anybody can clip it and talk about it. I don't care. We're good to go. Name it the Omar Serrano tie. That's coming soon. We're only just now bonding together, say cheese. Why are you trying to move things so quickly between me and this tie? And dating contract doesn't come until day 3. Come on. What is it? Your first time? Just kidding.
Girl,
Oh,
you're
the main
already
chat. Whoops.
pregnant. You just met the tie.
You just met
What are
the
you talking
tie.
about?
Oh, the main chat. All right, let me delete that. Winks. I'm sorry. I don't know. I'm just here. You might have to read today because I don't have words for anything. So, okay. Elbow Feet's just over here, just being like, say, oh, like, don't you smell it? Don't you see? He's like, I'm gonna need that. I'm gonna need oh, you already moved it, Winks. I'm sorry. I was doing my best. It's too late. You must wear the tie with intention. Yes, you must. Whew, there's a lot of intent here. Let me tell you what. All right. Somebody find out what the columnist says, okay? Please and thank you. Has he ever said before? If so, I'm gonna need it. All right. So, what are we supposed to read today? I don't know. I don't know what we're supposed to be doing today. I don't even care. I don't even care. Yeah, y'all need to ask him. Trust me, you will think finding that answer. Go to the store, smell it, and you'll be like, yes, put it on everything. Put it on everything. Okay. So what we're all here for today is we're going back in the timeline. So do you receive +5 sexy points when you wear the tie? I think so. I mean, I'll be honest, I feel pretty good. So it just has that, what are the kids aura going on? The aura of sexiness. So oh yeah, good luck to your husband and stuff. I hope it goes well for him today. It's a big day for some of y'all, but I won't talk about it on this stream. We'll have to wait for the update for Hellbills tonight. Um, so good morning, Berkeley. You've missed a lot. You've missed a lot. Llama is punch drunk on this tie she's wearing. Omar's tie that smells so good. I don't even know. So yeah, so we're not going to talk about the bankruptcy because I only heard part of what the mock hearing from yesterday. Because I had a very, very busy day today or yesterday, and I only picked up some of the end of Hellville, so I don't really know much about what went on at all to talk about it. But what I have heard was, oh boy, and clink clink, like it's not great. It's not great. Um, so I really can't wait for it to come out. I know that I saw it was a 2.5 hour meeting. And some of the things, because Hellville had listened in to the call, right? So she had all of the notes from that. And oh boy, I cannot wait to hear just Jan's tone as she's answering things and all of the wild excuses she's come up with. I know that there was something about using the GoFundMe to pay off their Macy's card and life insurance, but Queen Jen would be like, and then why? Why would you choose to pay that? So I can't wait till it comes out. Her stream is becoming the poop stream. Well, mine usually do. It's fine. Everybody poops, guys. Everybody poops. So I think it's gonna be riveting to listen to. And I mean, I haven't heard it, so I don't want to make too many insinuations about things, but it does sound like, uh-oh, somebody's done fucked up. And like, I just don't understand. Oh, there's also money moving from like them to Sarah. I don't know. I don't know. But when it comes out, it's gonna be good, y'all. I know everybody's gonna be covering it for sure. But it's gonna be one of those, just like with their last hearing, I feel it's gonna be one of those like where you have to listen to it over and over and over again because you're just like, what? How is this happening? How is this happening? You know, I don't know how people are okay with lying to the not okay, but okay and like so brazen to try to deceive the federal government when it comes to money. Like, what planet have you been living on? That's their bread and butter. Like, you think they don't have a bazillion forensic accountants? Are you serious? Like, come on. Come on. So, oh, it's unbelievable from the sounds of it. I can't wait to listen to it. Don't worry, we will listen to it and we will talk about it. It's 2.5 hours, which means it'll probably end up being like a friggin' 6-hour long Buffy and Llama stream, which that's fine. I don't have any plans this weekend. I can't do anything. I can't go outside. It's too smoky and dangerous out there, so might as well talk shit about the Owens. So, um, excuse me. I wonder if the official recording oh, Mother Pugger. I love your name so much. Um, we'll have the last 5 to 10 minutes on the record. That part was super juicy too. Or hopefully someone just has it recorded since it's off the record. Maybe okay. I wouldn't risk somebody having the recording of off the record stuff. That's probably even worse. But maybe they will. I don't know. Added D&D stats for the tie. I love it. You're welcome into our nerddom. You're welcome. Does anybody play D&D? Like that's like a dungeon master or something? Because we've talked about wanting to play sometime. None of us know how, but we've like tried to find somebody that'll put together the game and let us play because we don't understand it. But we're like, yeah, fucking yes. Why not? We love getting in character. We have murder mystery parties. We take our roles very seriously. I mean, hell, Buffy was married to Elbow Feet for some time. Mm-hmm. So if you know
Yeah.
somebody, just slide in my
That was an
DMs.
interesting match.
Yeah, I can't wait to see what Tiff has to say about all of it as well. So make sure all your notifications are on there too, because I'm sure she is definitely gonna be right on it. So you've always wanted to learn too. Me too, right? But like, I don't know. You're not a dungeon master, but you love to play. Amy plays too. Amos does. So I know you do. But are you a dungeon master? No, you're not, Amos. Come on. Come on. Um no, nerd. Is that a no? That means a yes, Savage? Because I think it is. I don't know. You guys are getting all my secrets because I would confess to anything. Stop telling you. What do you want to know? The tie's just making me not think straight, so it's fine. There's a YouTube channel that sets up games. He had 2 campaigns with. Oh yeah, I know. I loved when they were doing Lawyers and Dragons. It was my favorite way to spend Saturday mornings when they were doing their campaign, and it looked so much fun. And I was like, I want to do that sometime. And I've never found anybody. Because I know some people are also like, yeah, but like you guys are all new and don't know what you're doing. So like also we just don't have anybody. So but yeah, Lawyers and Dragons is so much fun to watch. Where's it all on? I think it's on what Hogue Law's channel still. Um Great fun time. I feel like Bruce would be a good resource for D&D things too. Where's Jupiter Jane to pressure him? Just kidding. You were a big D&D girl in the 90s? Oh my gosh, look at how nerdy we all are. I love that. I love that. Berkeley says I'm nowhere near Tiff's experience in acumen, but I can math and I can tell the math doesn't math. That's right, Berkeley. I want to hear your take on everything. You should come on and tell us sometime your take on things because I know you do math stuff. All the mathy math. We don't do math. You prefer the Pathfinder version of D&D 3.5 rules. I think that's the one that B talks about, elbow feet, but he doesn't want to be a dungeon master. He's like, no, thank you. It's a lot of work. And I was like, what? Right? I feel like it's 3.5. I feel like I've heard that before. So anyway, if you ever want to do that, just slide into my DMs and we can do it. Doesn't even have to be on camera. I can just be in Discord. I don't care. Though I have no problem showing my nerdiness to the world. So, all right, friends. Thank you for talking about the bankruptcy meeting, though. I've needed people to talk with about it. I was freaking out yesterday and had no one to talk to. I know. And see, that's the thing is like I haven't even read what all went down. So I did not have time yesterday. It was like boom, 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 boom from the time I woke up. And then I was just like, man, it's busy. I didn't even get to read Big Brother stuff all day yesterday, guys. And if you know me, that says how busy I was. But okay. Well, you know what, guys? Enough distractions. Let's get into what we have to do today. So we are reading, share this tab instead. You know what I should do? I should open that bottle of champagne I have in my fridge. That's what I should do. He's like, no, llama, no. So let's see. This is a motion to okay, so this is where we left off last Friday. So we are now in July 12th, 2024. So 2 years in the past, this is after the paternity trial. David has filed that he wants a new judge because this judge is biased and her dad was there and it was ridiculous and she just needs to go away, right? Excuse me. Bye, Ivy. Good luck with your meeting. And so he was like, I want a new judge, even though it's all said and done, because her daddy was watching and had his own opinion about things. And apparently she shared information with him, yada, yada, yada. So that's kind of where we left off. And it was very annoying. It was very annoying. Now, he wasn't wrong. Some of her things that she wrote in her order, her decision, were inaccurate. They really were. She got dates wrong, things like that. But I want to say that's enough for you to get a new judge. And yeah, I think perhaps it should have been a much longer trial. David and I don't disagree on everything, but most of the things. All right, I'm trying to minimize certain things here. All right. Just crickets. Crickets for what? Oh, you started. Oh, oh no. That's funny. She's a very busy lady. She might even have her grandbabies with her. So, all right. So, this isn't now a motion to vacate the judge's judgment. No more of that. We want it thrown out. And we want a motion for a new trial and alternatively, a motion to alter or amend the judgment. So if we can't get a new trial, we would like this one to be rewritten and probably benefit us. And motion for leave to exceed page limits because it's David. It's David. We need more paper, please. All right. I can't fit in all my points in. How many pages is this? 32 pages, David. 32 pages. Okay, sorry. Let's see. So, oh God, we're gonna have lots of rolls. All right, everybody, you got your drinks ready. I hope so. Some Tylenol for the headache you're gonna have. You're probably gonna need that. What else are you gonna need? Hmm. All right. So, pursuant to, hold on, let me bump this up a little bit. I'm sorry, I'm all over the place. Look at what this tie does. Oh my goodness. All right, bye. Have a good weekend. We love our replay crew as well. Bye, Berkeley. Pursuant to Rules 83 and 85, Rules of Family Law Procedure, Laura moves for an order vacating the judgment entered in this matter on June 17th, 2024. And in addition, Laura further seeks a new trial pursuant to Rule 83B, as well as other relief as stated herein. Now, this is different than his other filings, just to let you know. It is not, there's a lot of other things he brings up in this one that he did not bring in the other one. Yeah, get the kettle ready, guys. Oh, coffee ready and some electrolytes because you got 2 real babies to breastfeed. Girl, oh my goodness, yes. Yes. That tie wait, where'd it go? That tie got you higher than the Owens Macy's car tab. Yeah, yeah, it has. Yeah, it's magical. It's a magical tie. All right, so introduction. As the docket in this case reflects, on July 8th, 2024, Laura filed a notice of change of judge for cause. As of the date of this instant motion, that notice remains pending. Per Family Law Rule 6.1D4, although this matter currently remains assigned to the notice judge, Honorable Julie A. Mata, if the matter is reassigned, the present motion will be decided by a new judge who is not familiar with the extremely complicated procedural and factual history of this case. How many things did we read where David was like, this case is simple. I don't know why we're trying to make it so hard. All right. It's not that hard. How many did we read? Where that would be like his first sentence. Numerous, I think. Oh, needs his own tie. I agree. Ties for everybody. Omar can just start a business. He'll sell like 100 of these by tomorrow. Just saying. As this docket in this case reflects, oh wait, I already read that one. I apologize. At the same time, while this matter is temporarily on hold due to the notice of change of judge, the 25-day time limit to bring a motion under Rule 83C1 continues to run. Oh, he loves his day counter. That deadline, which expires on July 13th, making the last day July 15th, 2024, also necessarily controls Laura's time to appeal, and it may not be extended by stipulation or court order. Accordingly, although she would prefer not to do so until the issue of disqualification is resolved, Laura has no choice but to bring the instant motion. No choice, you guys. None. So let's get into this factual history. Because this motion may ultimately be decided by a new judge, by the way, I don't think it is, who is not familiar with the case, some brief remarks are necessary before specific issues are discussed. First, assuming the motion is heard by a new judge, to understand the complicated factual and procedural history, the court may wish to review a few key pleadings, including all of these things we've gotten to read, which seem to all be Laura's stuff. So interesting. Includes Laura's notice to change a judge. That was what we read Friday. Both parties' pretrial statements, Laura's request for findings and facts and conclusions of law, Laura's motion for judgment on the pleadings, Laura's motion for extension of time to respond to respondent's motion to compel. So why do they need to read that one, David? That's the very first one we read by you. Why do you hate the new judge already? Like, it was ridiculous, sir. Nobody should read that. Laura's motion to dismiss with prejudice. I mean, I'm just saying for the last one, like, what judge is like, oh, so you wrote 39 pages about asking for more time? What? No, don't show them that, David. It's embarrassing. Embarrassing. I wonder how many parties in family court want new judges when the decision doesn't go their way. In any court, it happens all the time. All the time. It's like they're always saying something like that. Um, Let's see. Oh no, I'm sorry you're so stressed out, Tony. Good morning, Mary. Good morning. Hope you're doing well today, babes. So these are is it from waiting for the mock? It'll be fine. It'll be fine. Don't eat your fingers. You're going to need those to type lovely comments. Please and thank you. And hit that like button. These pleadings generally explain the story, and despite appearances, most, but certainly not all, of the material facts were undisputed. In short, Laura claims she had a one-night sexual encounter with respondent Clayton Echard on May 20th, 2023. Laura claims sexual intercourse occurred, while Clayton claims only oral sex and genital to genital grinding or rubbing took place. Oh my gosh. Oh, Ty, calm down. That's for later. No, just kidding. Just kidding. Always with the grinding and rubbing, though he left out the finger banging. But what are you gonna do? What are you gonna do? Laura then, of course, claims she tests positive for pregnancy, um, and on multiple other occasions, including peeing on all the sticks she could find, then files this on August 1st. Okay, that's kind of meh, 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 meh. You guys know the story, right? So we're just going to kind of skip this part. It's all he files pro se, denying it. Then they have the Ravgen thing. And again, this is all David's side of the story, which doesn't even make any sense, but okay. A bit of bending the truth, if you will. And then the whole HCG level of 102, all of that. Learning that it failed. Laura decided not to do anything or say anything because she's a great person like that. And she wasn't going to do anything, but here we are. And a lot more of, Greg Woodnick comes in. They're trying to make a big hoopla. They file their motion for 26 sanctions. Drink, everybody. We're already there. um, and they ended up withdrawing it later, the Rule 26. Da, da, da. Shortly after, Laura's counsel, Alexis Linville, sorry, Alexis, appears, but then quickly is like, "Ooh, I'm peacing out. Okay, this is no thank you. I don't want to do this." So she leaves in like what, 2 weeks? A week? I think it was. What was it, Buff? Do you remember? I want to say she came on like December 22nd or 28th, and she was gone real quick. Now,
I am not the date person. I don't remember dates.
that's true, I suppose. You never know. Just test you for when we do trivia.
Oh, I didn't know there was gonna be a test.
That's okay. You can still be on my team. It's fine. We should do a huge, because I know Bruce put together that for the fundraiser and we never got to do it. We should do it soon. Trivia or other things. Maybe some grinding and rubbing of shit or something. Oh my god. I am
Oh my
out of
goodness.
control, guys. I
This
am
is
out
the
of
FW stream.
I don't know. I don't know. I don't know. Now, confusingly, on January 25th, Judge Mata issued an order granting Laura's motion to dismiss. And in that ruling, petitioner advises she's no longer pregnant and has filed a motion to dismiss, while the court will grant the motion. The issues of sanctions and attorneys remain. And Judge Mata then set an evidentiary hearing on those for June 10th. He's right. She was like, yeah, she's not pregnant. We're not doing paternity, but we are going to talk about all of these other shenanigans. So then David comes on the scene, which was something, probably one of the worst mistakes he's ever had, quite frankly. He lost a lot by taking on this case, a lot of things. And then after appearing in this case, undersigned counsel quickly discovered Mr. Woodnick filed the Rule 26 motion for sanctions, among many other pleadings, without first consulting Laura or her counsel, and the whole safe harbor BS. We're not gonna. And then Woodnick filed a motion to withdraw it. Okay. On May 29th, 2029, get it together. You and it. Oh, David. David. You
Oh,
sat
he's not a
there.
date guy either.
But if you're gonna jump on Mata of her getting the dates wrong and blah, 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 and here, look at what you've done. You put this 5 years in the future, David. How are you gonna be
No, we
like,
haven't even
yep,
gotten there yet.
she's wrong. And then you go and you mess up. David. Oh my goodness. Okay. So, so on May 29th, 2029, a minute entry order was issued explaining the court had intended to grant Clayton's request to withdraw his motion for sanctions, but due to a clerical error, the acceptance was not remitted to the parties. Despite the motion for sanctions being withdrawn and despite no other sanctions or fees pending, the case proceeded to trial on June 10th. All right. So then we're getting into after the trial. So on June 17th, 2024, filed the 18th, Judge Mata issued an order finding in favor of Clayton as to substantially all issues in the case. That's not true. She upheld the protective orders because she's like, this is not like, she can't do it, right? And that's true. Substantially all issues in the case, awarding attorney fees and an amount to be determined by later application. The post-trial order also purported to find Laura lied about being pregnant in the case, as well as 2 other matters, and that she may, you guys, have committed perjury in this case or elsewhere. The order is not entirely clear. Why would you say or elsewhere? Oh no, David. You mean like in her deposition? Or do you mean like under oath in her other hearings or elsewhere? David, why would you say that? Based on those findings, Judge Mata referred this matter to the Maricopa County Attorney's Office. Wendy says, what is this document we're reading? This is Laura's side. This is David Gingras' filing right after the paternity trial. This is him wanting with Clayton. This is him wanting a new judgment, a new trial, and just a lot of shit talking, which is, of course, most people do, right? You sent me an email treat. Oh my gosh, Tony, what is it? I'm being spoiled today. I don't know if I can handle it. Let's see. What is this? Here is. Oh, okay. Well, thank you. Thank you so much. And I won't. But thank you. You are so kind. So kind. Man, you guys are so nice. But thanks, babe. Thank you. Anyway, sorry, that was personal. I do not share. By the way, anybody sends me anything and it seems the slightest bit personal, I am not going to share it with anybody else. I don't, unless you want me to say something, I don't do that. And I prefer when people do email me that they do say what they're, I mean, I obviously know this one, but if you ever do, just put your YouTube handle like in something because that I will remember who you are then, as opposed to your real government name. But thank you, Tony. I appreciate that. Structural error discussion. As explained in detail in the notice of change of judge filed in this matter on July 8th, 2024, clear and convincing evidence shows Judge Mata violated Laura's due process rights and the code of judicial conduct. I mean, listen, we watched some trials where judges were not great. Very surprising that they were judges. I'm sure some of you that watch trials can name quite a few where you're like, what? That doesn't seem right. Judge Bev, ring a bell. Judge Gall, one. Who's the other one? The Aaron Spencer judge. I can't remember her name.
I don't remember her name either.
They were all trash. Just put it that way.
Judge Gilday is not doing too hot right now. So
Yeah.
there's a few judges that I'm like,
Exactly. Exactly. Okay, where was I? So, Judge Mata violated Lord's due process rights and the Code of Judicial Conduct by conducting a secret, undisclosed investigation into the facts of this matter. Oh, no.
Oh my goodness. Dun
Secret.
dun dun.
Secret, undisclosed. Oh, my goodness. Worse? What could be worse, David? Judge Mata not only reviewed social media posts about this case, she literally made at least one key factual finding or more based on those posts and not on the evidence admitted at trial. Straight to jail. Straight to jail. Let's go. Wow. Okay. We're kind of we're blowing up things over here, but I think you're hyping it up more than what it originally would be. A little hyperbolic, I feel, but okay. Bruce says if she really had to do an investigation to inadvertently say Planned Parenthood was closed on Sunday in a ruling, it's not much of a secret, is it? But he is a genius and figured it out
No,
before
he just
everybody
wants to
else
make it.
gross. Like, come on.
He wants to make it sound more nefarious than what it is.
Yes, absolutely. Part of this conspiratorial thinking that
It's a
he has
smear campaign.
a smear campaign. Oh my gosh. Which, by the way, also back to Hellville's stream from last night. She's got some merch. She has this shirt. Oh gosh, it has a picture of a bagel because she's from New York. I know that. I'm gonna get this saying wrong, but it was like something like, "I am part of a non-official smear campaign" or something. It's hilarious. I love it. I'm gonna have to probably order that because it was fantastic. You can't see me, but you're clutching your pearls. I know you should be. I'm clutching the tie. The horror. The horror. So, okay. I mean, I would think they would be closed on Sunday. I mean, do I know that to be true right now? No. But
I think most places are closed on Sunday. I don't know very
yeah,
many places that aren't, besides like a urgent care or a
yeah,
hospital.
yeah, exactly. Like I don't, and a Planned Parenthood of all of them that gets a lot of heat about things. I would go with are probably not open on Sundays. So I don't think this is the shocking part, but he's doing his best, I guess.
He is zealously advocating for his client.
I don't even know if zealous is a
There-
strong word
I
for
don't-
it.
I don't know if you sense the eye roll. There was an eye roll.
Oh, no, you're right though. But this is ooh, yikes. All right. So worse, Judge Mata. Oh, I'm sorry. I already read that part. The consequences of this are both simple and clear, even though I told you everything is super complicated. Laura is entitled to an order vacating judgment in its entirety. Rip it up, throw it out. Judge Mata's ruling is trash. Her words are trash. New person reading this, whoever it's going to. I didn't see who this is going to. I think it's just Judge Mata, right? Hold on. Please hold. Oh, it's just going to Judge Mata. Okay. So that's great. She's going to love that.
I know. I wonder how judges feel getting emotion talking about how crappy they are, getting sent to
Right?
themselves. It's like, dear judge, you suck.
You suck.
And
you're
here's a
ugly
32-page motion. There's a 32-page motion on why. I told
Right?
you, if you say people's names out loud on a stream, they appear.
They do. I've been talking about you, Hellville. And then boom, there you were. Like magic. Like magic. Are you done with your appointment today already? I hope so. I hope everything went well. And Hellville, did you see what I have? You're going to have to go back and watch earlier to know what was sent to me. That I was like, no, nobody's allowed to know. Where was I? Let's see. Okay, so pursuant. Wait, no. The consequence of this are both simple and clear. Laura is entitled to an order vacating judgment in its entirety, and she is entitled. She is very entitled, yes, but I don't know about for a new trial before a different judge pursuant to family law rules, blah, 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 blah. And what they provide in relevant part. 1, grounds for altering or amending a judgment. The court may, on its own or on motion, alter or amend all or some of its rulings on any of the following grounds, materially affecting a party's rights. A, the court did not properly consider or weigh all of the admitted evidence. B, he must have underlined these because we're all idiots and so is Judge Modis. So thank you, David, for underlining these. Thank you. B, any irregularity in the proceedings or abuse of discretion depriving the party of a fair trial. C, misconduct of the other party. D, accident or surprise that could not reasonably have been prevented. E, newly disclosed material evidence that could not have been discovered and produced at the trial with reasonable diligence. F, error in the admission or rejection of evidence or other errors of law at the trial or during the action. Very vague. G, mistakenly overlooked or misapplied uncontested facts, including mathematical errors, which were necessary to the ruling. Or H, the decision, finding of facts or judgment is not supported by the evidence or is contrary to law. Look at all those points he has. He's going to win it. I think, you guys. I think he is. I mean, how could he be wrong? I'm just kidding. I'm just kidding. Hi, Negla. Right? Like, sometimes you need to step back because you did kind of walk her through not so great, possible felony charges. Well, she got them. So, yeah, she didn't share it until then. So, like, oh, I know it doesn't. Her new hair is amazing. Everybody tells her that every day, and you should make her feel good about herself. No appointment. It was pushed. Did you have to do all the prep anyway? Oh no. Oh no. Well, that's okay. Oh man. Yeah, you will. You will. You will have to do that. All right. So when grounds exist to do so, Rule 83B provides that the court may vacate the judgment if one has been entered, taken additional testimony, amended findings of facts and conclusion of law, or make new ones and direct the entry of a new judgment. Here, multiple grounds exist for relief under Rule 83. However, because the improper conduct of the trial judge deprived Laura of her most basic right to fundamental fairness, it is not necessary to consider any issues but one. Don't worry about all the other stuff, just this one. The independent investigation into the facts undertaken by the trial judge, Julie Mata. That single event, standing alone, invalidates the judgment in its entirety. Gotcha, Judge Mata. He didn't say that, but we know that's what he's definitely saying out loud when he writes this. Without regard to the other, lesser but still significant errors of both fact and law committed by Judge Mata. As such, that issue will be discussed first. Assuming the court agrees and orders a new trial, it is unnecessary to consider or resolve any other issue at this time. Those other issues will still be briefly addressed solely to preserve the appellate record. And I can't write anything under 30 pages. So we're going to hear about it. Do you mind, Buff, taking this over so I can go use the potty real quick, please? Thank you.
Okay. So we're at before addressing. I
The
gotta read
A.
that part.
Yeah.
Judge Mata's undisclosed independent investigation
coffee.
into the facts was structural error, can't say that word, requiring automatic reversal of the judgment and a new trial before a new judge. Let me pull this up on my end because You probably went back in time. Okay. Before addressing other issues pursuant to family, there's going to be dirty talk. Are we past that?
Dirty talk?
I feel like
What?
you're setting me up.
I'm not setting. What? I'm not setting you up.
Mm-hmm. Mm-hmm. I know how this goes. It always goes. Okay, before addressing other issues pursuant to family law rules 83A1B and 85B6, Laura moves for an order that the judgment be vacated in its entirety and a new trial ordered before a different judge on the basis of misconduct committed by the trial judge, specifically as explained below and in the notice of change of judge for cause filed concurrently herewith, which is incorporated by reference herein. Okay. There is clear and convincing evidence proving that Judge Mata violated inter alia Rule 2.9. Oh my God, this man and his rules of the Arizona Code of Judicial Conduct, which provides, except as otherwise provided by law, a judge shall not investigate facts in a matter independently and shall consider only the evidence presented and any facts that may properly be judicially noticed. Emphasis added. Laura has separately reported this misconduct to the Judicial Conduct Commission. Wow. Okay. Here, irrefutable evidence demonstrates Judge Mata violated Rule 2.9c by conducting her own internet research into the facts of this case. She did so by reviewing information posted online regarding this case. And even worse, she adopted one or more statements of fact into the judgment, which were not based on the evidence at trial, but rather were based solely on statements published on the internet by Clayton's supporters. A. Legal standard. Few legal rules, if any, are clearer than this. Both federal and state constitutions guarantee that no person shall be deprived of life, liberty, or property without due process of law. And then he goes to talk about Meckham versus Gordon. The touchstone of due process under both the Arizona and federal constitutions is fundamental fairness. Blah, blah, blah. A party's right to fundamentally fair trial is critically important because it preserves both appearance and reality of both the appearance and reality of fairness. Okay, generating the feeling so important to a popular government that justice has been done. Okay, whatever. Fundamental fairness in the context of due process has many different facets. But the key one is this. All litigants and all courts are entitled to have their cases heard and decided by a judge who is fair, neutral, unbiased, and impartial. Although the right to a trial before an impartial judge is not specifically enumerated in the Constitution, this principle has long been recognized by the United States Supreme Court in State versus Dorsey to maintain. Oh yeah, I'm on page 7.
Okay. I was like, what? Okay. Sorry.
To maintain public trust and confidence in the judiciary, judges should avoid the appearance of impropriety and should act to assure that parties have no reason to think their case is not being judged fairly. Citing Rose v. Clark, and then Toomey versus Ohio, Greer State. Okay, whatever. The denial of due process is a denial of fundamental fairness, shocking to the universal sense of justice. Although Arizona case law on this exact issue is sparse, because instances of judicial misconduct in this state are thankfully rare, the United States Supreme Court has repeatedly agreed the due process clause requires trial judges to be fair and unbiased, and the requirement is not illusory. I can't say that word. It's too many vowels. The deprivation of a fair and unbiased judge is a structural error requiring automatic reversal of the judgment. See Nieder versus U.S. What?
Oh, nothing. I was trying to find us. I was like, there we are. On my side.
Discussing difference between harmless error and structural errors and explaining we have found an error to be structural and thus subject to automatic reversal only in very limited class of cases. Such defects as the complete deprivation of counsel or trial before a biased judge. Oh my gosh, so much citation. See, this is the kind of stuff I would just be like, yeah, I don't want to do this. Like, I would never write this. This is why I could be an attorney.
I know, right? I'm like, okay.
As it must, the Arizona Supreme Court embraces the same standard. In cases involving trial error, we consider whether the error so assessed was harmless beyond a reasonable doubt. If so, we uphold the verdict entered. In a limited number of cases, however, structural error occurs. In such instances, we automatically reverse the guilty verdict entered. Unlike trial errors, structural errors deprive defendants of basic protections without which a trial cannot reliably serve its function as a vehicle for determination of guilt or innocence. And no, punishment may be regarded as fundamentally fair. Okay, so another citation, State versus Ring. Presumably, due to the high ethical standards of most Arizona jurists, comparable instances of a judge conducting an undisclosed investigation into the facts of a case and then adopting findings based on that investigation has occurred here. As occurred here are essentially non-existent. Okay. How? Yeah, because how do you fucking prove that?
Okay.
Like, I mean, unless you have like Google, unless you have whoever it is that's on Ben's team just going through Google searches, you know, turning over everybody's data. How do you do that?
Mm-hmm.
I don't know. Okay, so
Doesn't matter.
however,
Don't talk about it though. It's fine.
oh, he's going to tell you about
gonna
how
tell
it's
ya.
true, even though he has absolutely zero proof and can't prove it because he's just throwing things at the wall to see what sticks. Okay,
Which is nothing.
he's just a sore loser, is what it comes down to. Okay.
Yeah.
I don't even know where I was. I went on a rant. Presumably due to
That's
high
okay.
ethical standards of most Arizona jurists, comparable instance of a judge conducting an undisclosed investigation into the facts of a case and then adopting findings based on that investigation as occurred here are essentially non-existent. However, courts in other states applying the same legal standards are in unanimous agreement. It is structural error requiring automatic reversal when a trial judge conducts an independent investigation into the facts of a case. This is so because the bedrock due process requirement of fairness requires that conclusions reached by the trier of fact be based upon facts in evidence and prohibits the trier of fact from reaching conclusions based on evidence sought or obtained beyond that adduced in court. Okay.
Right. So like the he's just going for the date of the Sunday thing. That's all he has, which is not going to
he's
be
just
enough to overturn anything.
He's just beating a dead horse, in my opinion.
Yes. Yes, really. I mean, listen, everybody always files an appeal to things. That just happens. But like, okay. All right.
He just argues the same shit over and over again. It's so obnoxious. It really is. Like, it's like, oh my God, you said this 10 times.
Yeah, but that's so you can understand it because
I know we're stupid.
Little dum-dums. We're just little dum-dums.
We're all stupid. I don't like to be treated like I'm stupid. Thus, if a judge, especially in a bench trial, undertakes a personal investigation into the facts of a dispute or makes filings based on his or her own independent research or knowledge rather than based on evidence admitted at trial, this conduct is a per se violation of the Due Process Clause, which constitutes structural, not harmless error. First, the judge sitting as the finder of fact indicated by her comments during Worthy's testimony that she believed, based on facts, not in evidence, that Worthy's statements about the date of Paige's death were likely false. So this is Got to be like this is another
Yeah, this is different
case
case.
law. Okay.
Mhm.
It's like, whose page? How'd you die? I need to know.
Whose page?
Right? These comments disregarded the judge's duty as the finder of fact to make factual determinations solely on the basis of evidence in the record. Second, the judge independently investigated a fact not introduced into evidence, violating her obligation as the finder of fact to refrain from seeking or obtaining evidence outside that presented by the parties during the trial. In Price Brothers Company versus Philadelphia Gear Company, I'm guessing, the Sixth Circuit Court of Appeals stated unquestionably it would be impermissible for a trial judge to deliberately set about gathering facts outside the record of a bench trial over which he was to preside. Man, all the case law. Dorsey at 701, blah, blah, blah. What's that?
Nothing. Dorsey. That was just like, of course. Of course. Of course, we're still going. Don't worry, it is not case law for the whole 30 pages. Just
It
by the
sounds
way.
like it.
I know it sounds like it, but it's not in my breezing reading that I did earlier. At least that's what I took from it. But we'll see.
Okay, so reversing defendant's conviction and ordering a new trial upon finding trial judge violated defendant's due process rights by conducting improper ex parte investigation into the facts of the case. Ordering a new trial where judge in bench trial considered facts not admitted into evidence and reaching this conclusion. The law on this point could not be any clearer. Judges are absolutely forbidden. Both as I know, it needed to be echoey and loud. Like it needed to sound like it is forbidden. Bidden. Right?
Your echo.
Both as
boistering.
Yeah. Both as it was very Mufasa. Like it is forbidden. Right?
Nice.
Both as a matter of due process and judicial ethics to conduct independent investigations into the facts of a case. And they are absolutely forbidden from making factual determinations based on the results of those investigations. Findings of fact may only be based on evidence admitted at trial or matters which may properly be judicially noticed. A judge shall...
So Wendy says, Lo and Buffy, do you guys want us talking more in the other chat so it'll be more active? I'd appreciate it if you talked more in the Couch Court with Llama one, just because that's going to help that channel get up and going. But I understand that people are split between two chats. Don't worry. It won't be that way for very long. But the more activity that the Couch Court with Llama channel gets, the better and quicker everything just is going to be over there. So like next week, we might shut the chat off for the True Crime and Wine Time stream and just have it open on Couch Court. But we're not trying to change too much because not everybody gets to watch us every day and so I don't want them thinking we've left them to stray. But yeah, the more you give over on the Couch Court with Llama channel, the quicker that channel is gonna, we're gonna be able to move there. But I understand, more people are one, or you might have memberships on the one where you can use the fun emojis or whatever. I get it, but it is helpful just to clear that up for you guys, because I do know it's a little confusing, but also like we don't want to. We just want to give people more notice and time to move over and join when they get caught up, so that way they're just not like, where did everybody go? So
yeah, half the chat is split.
Yeah,
So
yeah,
I know
that's
that makes
okay.
it confusing.
I know. But anyway, sorry. I don't know where you left off either.
Okay. No, I don't know. It probably doesn't matter. He's saying the same thing over and over again.
Okay, that's fine.
So I don't really know. The
We'll
law on this point can...
Yeah,
What?
just go ahead. You're fine.
No, go ahead if you want to.
Oh, I was just going to say, you could probably come down all the way down to here, where they're starting to talk about the formal opinion. The Aston formal opinion.
American bar ass and formal.
Asin.
You know what? No. It's ass and formal opinion. Like it should be like the name of a bar. American bar ass and formal opinion. Formal opinion. I like it.
that.
Let's do that. I want American ass on my shit.
See how, Bill, we talk about bust stuff on ours too. It just happens organically.
I don't
What are
know.
you gonna
This is
do?
actually how most of our DMs go too. I don't know how it gets there.
At least once a day.
Unfortunately. Or fortunately, depends on, what we're talking about. So, all right. So, explaining a judge may not use an internet search to determine hours of operation, nor are business hours properly subject to judicial notice. This internet search violates Rule 2.9C of the Model Code of Judicial Conduct because the restaurant's hours of operation are key to whether the plaintiff could prevail. All right.
But like, couldn't she have just looked at her desk count? Like, he's implying, by the way, his whole argument is going to be, well, she found out that it was Sunday because she read my blog and it said so in the comments, which is wild.
Sure.
To be like, it was on my blog and she had to have seen it. Like,
it's always about him.
She also has
he's
like
so
a calendar
popular
right there. American Bear Bar ass. I love it. I
like it. I like all formats of that.
Thank you guys for chatting for the algorithm. Absolutely. Thank you so much.
All right. So when a judge ignores the most basic principles and conducts an independent investigation, the result is structural error, requiring automatic reversal, regardless of whether the ex parte evidence found by the judge is true, false, or completely accurate. What's the difference between true and completely accurate?
I don't know.
I would feel like completely accurate would be the same as true.
Right? I don't know. What do we know? We're arguably famous. What do we know?
We're dumb.
Thank you, Hellbill, for becoming a member. Thank you so much, babes. Appreciate your support. We have tons of member-only content. Lots. Coffee time with Terry and Llama. It gets crazy. Llama learns about all that fun stuff. If you want to become a member of the True Crime and Wine Time channel, just click the join button. And all of our shows, I think, are bestie levels and higher or something like that. But thank you so much, Hellbill. We appreciate you.
No, we haven't seen it.
No, it's not. It has not been released to the public yet, the hearing. So maybe later today, but maybe not till Monday.
If we get it, maybe we'll go live over the weekend. Who knows?
Yeah. Yeah, I mean, if it comes out later tonight, then yeah, we'll definitely stream over the weekend. It probably won't be later tonight, I'll be honest. But we'll see. Sometimes it takes a couple days. Sometimes they get it right away. I don't know. So we'll just have to wait.
How motivated the court is at any given time.
Right. So.
All right. So we conclude that Dorsey was deprived of the basic protection of an impartial judge and finder of fact when the judge independently investigated a factual assertion made by a key defense witness and revealed the results of her investigation to counsel. This deprivation constituted a structural error, which precludes harmless error analysis and requires we reverse without regard to the evidence in Dorsey's particular case. Okay.
Nice. Yeah, I was gonna say we can probably skip that whole paragraph there.
I'm over the case. Yeah, you're being. Yeah. I get it. We get it. They're not supposed to do outside research. Okay, but you still haven't proved that.
Day of the week. There were 7 of them, and she guessed the right one. It must be a conspiracy. Just Jen says, oh, look, here's one of our document fairies. Just Jen says, good morning. I don't think we'll be getting the mock audio until next week. The person who handles it is out until Monday. Well, that's okay. We will patiently await.
The shit
Um,
show.
but I know that Hellville listened in on the call. She did a stream last night and she's doing part 2 tonight at 6 p.m. Is that right, Hellville Eastern? So she has lots of notes for that. So I would recommend going and listen to her tonight. I probably will be, maybe unless I'm doing something else, but we'll see. You never know. Am I right?
Am I right? Am I right?
Am I right? Am I right? I don't know.
So on page 10 of judgment of the judgment, Judge Mata made the following finding of fact, which is purportedly based on testimony from Clayton's medical expert, Dr. Samantha Deans. She, Dr. Deans, testified that Planned Parenthood does not accept anonymous patients. They do not accept patients using an alias. Patients are required to provide a government-issued form of identification. She further testified that Planned Parent is not open on Sundays. When petitioner testified, she sought care July 2nd, 2023. I thought I heard that.
Well, that's what the judge wrote in her ruling.
Oh,
And he's
I was
saying
saying,
that
I thought I
part
heard
didn't
that
happen.
though.
Really?
Really?
Never mind this first part where your client lied on the stand about it, about being anonymous. Did she say that on the stand specifically, or was it in either way? Your client completely lied about it because it's not even how things work.
Why
But
do
he's
I
like,
feel
let's
like
not.
I actually heard that though? Like I feel so gaslit. Maybe I need to go back and listen to the testimony.
You'll get it without my ADD commentary. Oh.
Okay, so the underlying text quoted above proves conclusively that Judge Mata committed structural error by performing a secret, undisclosed ex parte investigation into the facts of this case. This necessarily included the judge reviewing information posted on the internet by Clayton's followers, which she then adopted as a finding of fact. That conclusion is supported by two things. Okay, let me have it. First, attached to the notice of change of judge is a true and correct copy of the transcript for the trial held in this matter on June 10th, 2024. Look, you got the date right. As reflected in this transcript, Dr. Deans never testified. Planned Parenthood is not open on Sundays. Nothing remotely approaching this was ever stated by Dr. Deans or any other trial witness. Okay, I guess I have to believe you if it's not in the transcript. Indeed, the word Sunday appears nowhere in the trial transcript. This leads to the second point. If the conclusion that Planned Parenthood is not open on Sundays did not come from the testimony of Dr. Deans or any other trial witness, it begs the question, where did that finding come from?
It could have also been, even if it wasn't mentioned in the trial, because I don't remember or not. That was quite a few weeks ago we listened to it. It could have been a special day for a date, like in the judge's mind, right? Like, oh, that's so-and-so's birthday. And it's like literally right before the 4th of July. Maybe they had plans to like leave or arrive somewhere on this. Like there's a ton of possibilities besides just she read my blog and she saw the comments. Like, no, there's plenty of other reasons that are also not nefarious, but okay. Oh my goodness.
I mean, are you supposed to just like leave all of your common sense at the door when you're like,
Yes. Yes.
I'm just saying. The finding was based on statements published on social media by Clayton's followers. This is how we know Judge Mata conducted an improper investigation into the facts of this case, because her finding regarding Planned Parenthood's hours of operation was not based on any admitted evidence at trial. It was copied verbatim from social media comments, including an anonymous comment posted the day of trial on the personal website of the undersigned counsel.
Because I know when I want to know the day of the week a date falls on, I go to David Gingras' blog. So that way I'll know. Because that makes way more sense than anything else. But sure.
Wild.
Oh, here's the so here's the comment from his blog. June 10th, Planned Parenthood isn't even open on Sundays in LA. Guess what day July 2nd, 2023 was? That's right. Laura yet again committed perjury. And this right here is why he wants the judge out.
Llama,
Because,
are you telling me you don't go to Gingras' blog for true and accurate?
I go there for
information?
everything. I mean, he, if I want to know about famous cases that he might have been on or, all of that, then yeah, of
I'm
course.
pretty sure
He does.
you're allowed to cite his blog in an academic research paper.
Probably, yeah, of course.
It's peer reviewed.
Like I love that he's like, well, she could have only have known this. She couldn't have used the calendar feature on her computer or on the desk or nope, it's all impossible. She had to use my website.
But he passed the bar the first time twice.
I forgot he's a super genius. So there's that.
Okay. This evidence is standing alone sufficient to prove structural error. As a result, Laura is entitled to an order vacating the judgment in its entirety and ordering a new trial before a different judge pursuant to Family Law Rules 6.1 and 83B.
Oh my goodness. I
don't know. You need some direction on spouting off bullshit. That's where you go first.
That's where you go. Everybody knows that.
Assuming structural error occurred, nothing else matters. Automatic reversal is the only permissible option. However, to ensure a complete record, Laura also raises various other arguments regarding factual and legal errors contained in the judgment and the pretrial proceedings. A, legal errors. I feel like we're on like Stranger Things chapter. And it's like the red title zooming in. It's like legal errors. Anyway, yeah. All right. To prevent this brief from exceeding 100 or more pages. Oh, for fuck's sake.
Oh boy. Okay, sure. Why not? To prevent from exceeding 100 pages. But you're asking for more pages. You said so in the title.
Uh-huh. Yeah.
Okay.
Yeah. Hey.
Oh my. Oh David.
What an idiot. I mean, yeah, in my opinion. A full discussion of all legal errors committed by the trial judge is impossible because it's just full of them. Instead, each point is only raised in the shortest format possible to ensure non-waiver for appeal. Sanctions were unavailable as a matter of law. On May 10th, 2024, Laura filed a motion for judgment on the pleadings and renewed motion to dismiss. That motion explained it was undisputed Clayton's counsel ignored, we forgot the D, don't talk about all the errors, the safe harbor requirements of Family Law Rule 26, blah, blah, blah. Rule 26. Oh, okay. 26C2A and C2B. Mr. Woodnick never made any attempt to meet and confer with Laura before seeking sanctions, and Laura was never provided with the 10-day written notice regarding safe harbor rights. We know. Because of that undisputed error, the motion explained the trial judge was not permitted to fix Mr. Winnick's mistake by granting sanctions under the authority.
Fix it.
Under
Okay.
As is true of substantially every other legal issue, the trial judge simply ignored this argument and awarded sanctions without any legal grounds to do so. This was clear error as a matter of law. The bench
Chair.
trial violated Laura's right to a jury trial under Arizona's Constitution. Did she ask for a jury? Did she waive a jury?
I don't think I've never
I
heard
don't
of
think
there
you
being
get
a jury
jury.
in family court. Like,
I will say
at
I
all.
never went in front of a jury in family court. I always went before just a judge.
Yeah, I don't think it applies to
It's not a
that.
criminal court.
No, well, you can have a jury
Okay,
in
let's.
civil court, but I've never heard of
But
anybody
it's family
having.
court.
Yeah, it's usually a very private
Why didn't you ask?
thing.
Why didn't
So
he
yeah,
motion for it?
exactly.
Like he has no problem setting up motions, writing ridiculous shit. He does 32 pages of it all the time.
All the time.
Like he could have just asked. I've
Right?
never
I've
heard of a
never
jury in
heard.
family court either. Because I certainly haven't had them the many times I've been to family court. All right. So just days ago, the United States Supreme Court issued a decision. Just days ago. Like, okay. The United States Supreme Court issued a decision explaining that litigants cannot be denied their constitutional right to a jury simply because the rules of a forum do not permit a jury trial. Just days ago, right? So like okay. In that case, SEC versus Jarksy, 2024, US Lexus 2847, blah, blah. The Supreme Court explained the right to a jury trial does not depend on the type of forum or the specific label of the claim at issue. What matters is whether the remedy sought is legal in nature. If so, the constitutional right to a jury trial attaches no matter what forum the case may be in or how the claims are framed. So it sounds like it does sound that way. But it wasn't like part of the law when this went to trial because it says it didn't get, the decision wasn't made until the 27th, which was like 16 days after Laura went to trial.
Mm-hmm. Yeah.
Okay. The Seventh Amendment extends to a particular statutory claim if the claim is legal in nature. What determines whether a monetary remedy is legal is if it is designed to punish or deter the wrongdoer, or on the other hand, solely to restore the status quo. As we have previously explained, a civil sanction that cannot fairly be said solely to serve a remedial purpose, but rather can only be explained as also serving either retributive or deterrent purposes, is punishment and therefore requires a jury trial.
But I don't think this applies to this at all. But okay. All right, David. That's fine. Tell us more about this thing that does not make any sense. But
to be clear,
okay.
Jarksy only addressed federal jury trial right under the Seventh Amendment, and that specific provision of the Bill of Rights does not apply in state court. See Fisher versus Edgerton, explaining the Seventh Amendment right to a jury trial does not apply to the states. Quoting McDonald versus City of Chicago, this point is irrelevant, however, because both Article 2, Section 23, and Article 6, Section 17 of the Arizona Constitution provide in pertinent part that the right to a jury trial shall remain inviolate, and courts interpret Arizona's constitutional provisions protecting the right to a jury trial consistent with the Seventh Amendment.
I don't feel like this applies here.
I mean,
Yeah,
that's
what do
really,
know,
I guess, every lawyer interprets things differently,
Well,
and
that's
that's
true.
what the argument is in front of the judge, and the judge has to say, yeah, that's not what that meant.
That's true. That's true. Leon Gray says he probably would have he probably would have hated a jury trial. Yeah, it wouldn't have helped the situation. I can tell you that. Also, Bill says the Sixth Amendment ensures the right to a speedy public trial by an impartial jury in all criminal prosecutions. Seventh Amendment only pertains to federal civil trials. I was going to say, I have not heard of a family court jury ever. So that,
But yeah, I guess it's his interpretation of the new decision that the Supreme Court just ruled on, saying that it's in all forums.
mhm.
So I don't know. I'm assuming the judge is like, yeah, that's not what that meant. But I would want to. Why would you have a jury for a family court?
Like, no. What are we doing, David? Come on. It's just waste. And you needed more pages. Okay.
Not to mention, like, family court sometimes takes like a whole hour, 2 hours. Like,
Yeah.
I would be so pissed. Yeah.
They're not going to pull a fucking jury in for that. Get out of here. Get out of here, David.
Right? Like, that just seems ridiculous. To be fair, in Fisher, the Court of Appeals rejected the appel. Okay, you have to scroll down just a little bit because I cannot
I'm
see.
sorry.
That llama takes up too much space.
Oh, scroll down.
Yeah,
my camel.
sorry.
You mean
Your camel and his toes.
camel and his toes.
Your camel toes. To be fair, in Fisher, the Court of Appeals rejected the appellant's argument that Arizona, blah, 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 providing for an attorney of attorney's fees in certain appeals from compulsory arbitration violated her right to a jury trial under Arizona Constitution. But that finding was based on two materially different facts. The possibility of a fee award here does not act as an unreasonable or significant burden impairing the right to a jury trial. Rule 77 in ARS 12133.
Right. We do call it the paternity trial, but it was, in fact, an evidentiary hearing. But yes.
Yes, it was.
Hi, Carmen.
But it was like it kind of just shut it down, right? It was like, no. All right. So a bunch of bullcrap. Both provide safeguards to ensure that the right to have a jury decide ultimate issues is not significantly burdened or impaired. The Superior Court is limited to awarding reasonable attorney's fees and expert fees and may decline to award such fees if it would create a significant economic hardship on the appellant. Here, both of these safeguards were entirely absent. First, as an initial matter, unlike Fisher, here the ultimate issues were not decided by a jury. They were decided solely by the court. That fact, standing alone, explains why this case is completely different from Fisher. Second, Clayton has requested an award of more than $150,000 in fees, and there is no provision for the court to decline to award those fees based on economic hardship. Yeah.
Sorry. I thought you were reading your own.
Fine.
I'm sorry.
No. You put it back up and and then you were like, wait, where are you? And I was just like, it's just easier to read it off first. So we're not trying to figure out where each other are.
That's okay.
Third, Clayton asked the court to find, and it actually did find, that Laura engaged in fraud and the other conduct that would be tortuous and actionable in a civil proceeding, assuming it was true, which it was not.
It was not. It's not true.
He is so boring. Like, he needs to spice it up. Like, I'm sorry, I don't like boring David. In effect, unlike the outcome in Fisher, what occurred in this case is that a single judge was permitted to decide all ultimate issues in the case. Yeah, sorry.
That's what the judge does.
I am so mad the judge got to have a say-so in this case because I just don't like that. Sir.
Like what?
You're an attorney.
This is
not the first time you've done this.
No.
It's your first day.
Oh my gosh.
What an idiot. Okay. and then award an unlimited amount of fees to punish Laura as a result.
It
This
wasn't
outcome
unlimited. There
It
was a
was.
number. It didn't just say
It had a
infinity,
line over the zero. It kept going.
right?
You just didn't see it. This outcome clearly and directly violated Laura's right to a jury trial under Arizona's Constitution. The court lacks subject matter jurisdiction over tort claims such as defamation, fraud, and extortion. In her very first substantive filing after retaining counsel on December 28th, Laura moved to dismiss this matter with prejudice. In that motion, Laura asserted the court had subject matter jurisdiction pursuant to ARS to establish maternity or paternity.
Subject
Because
matter
Laura acknowledged-
jurisdiction.
I know, it made me Daryl Brooks. Because Laura acknowledged she was no longer pregnant, the motion asserted the case was, say it with me, class, moot.
Moot.
And the court
That's our
no
first
longer
one of
had.
the day.
I
Wow.
know.
14
I'm
pages before we
disappointed.
got to say moot. Man.
The court no longer had subject matter jurisdiction over any issue other than attorney's fees, while noting Clayton was not entitled to fees because he failed to comply with any of the procedural requirements of Rule 26. Oh my God, he really is obsessed with that rule.
Like Rule 26. Oh my gosh.
Along these same lines, notwithstanding the fact that the court did have jurisdiction to decide issues of paternity, it is equally clear this court lacks subject matter jurisdiction over all the ultimate claims and issues decided at trial. That is particularly true given that the paternity was not a disputed issue that was ever actually or necessarily litigated. Really? You tried. The final judgment does purport to make a finding of non-paternity, but this relief is not provided for in any subpart of Title 25. In short, while presenting his primary claims as a request for sanctions, the substance of Clayton's arguments at trial were and always have been that Laura lied about being pregnant, that Laura published false statements about Clayton to the media, and that Laura attempted to use the fabricated pregnancy claim as a means to extort Clayton into dating her. All of these tort claims / theories would support causes of action if they had a valid factual basis, which they did not. But Clayton could not have litigated those tort claims within the limited jurisdiction of the family court, and he could not have invoked the family court's jurisdiction as to those claims under Title 26, Chapter 6.
Oh my gosh, 26 is his favorite number.
Really is. I wonder if he bought like gets lottery tickets with all 26s on it. Or something. Like it's kind of obsessive and weird.
And weird. It's not a very good number. If there are good numbers. But I think there are good numbers.
I don't know. I don't know anything about numbers. I don't think numerology. More into astrology. Traditional civil tort theories such as defamation, fraud, and civil extortion surely could be pursued in the normal civil department of this court, in which both
Scroll.
In which both parties would have mandatory right to have the ultimate issues decided by a jury. And why didn't you ask for a jury trial? If you are so mad about this that you have to make a whole section of your filing, why didn't you ask? You're not mad about it until after you lost. That's the problem.
Mm-hmm.
And where the available
Also, it's not a thing.
would...
Never mind, it's not a thing.
But if it was a thing, which you're claiming it is a thing that she's entitled to, why didn't you ask?
That's the kind of things that appeal courts, a lot of people for criminal cases, right? They'll appeal, they'll use ineffective counsel, but you also are required to do certain things. And if you don't do those things, then that's kind of on you. You
Right.
should have addressed, if there's a part of testimony that comes out and then the appeal, they're like, this is why it's all wrong. Well, it's well, why didn't you object in court then? So that's why also sometimes when you hear lawyers be like, well, I want to put on the record that I did object to whatever, that's surely the reason why, because appeals courts are like, well, why didn't you do the thing when you had the time to do the thing? And this is one of those things. So
It's wild. But he
Unleash
does that a lot.
the work drama, Mary. Why not?
But that's what he does. It's like he
Mhm.
complains about stuff that he didn't do because he wasn't there. He's new to the case. I don't know.
It's
He's just
before
stupid.
his time.
It was, but it's like, I mean, I get it. It was before his time, but it's your job when you take on the case to bring up all this shit beforehand, not bitch about it afterwards because it didn't go the way you wanted to. If it had gone the way you wanted to, you wouldn't have said a damn thing about any of this. Oh, by the
Yeah.
way, you know,
Mm-hmm.
it's just dumb.
It doesn't make
All
any sense, Bill, does it? No.
All right. So I don't even know where we are.
I think
Tired
we're
of
done
hearing him bitch
here.
about it.
We're in Indeed, I think. Yeah.
Indeed, not only could such tort claims be properly brought in and only in the normal civil division, as explained in Laura's request for judicial notice filed on April 12th, 2024, Clayton's counsel, Greg Woodnick, previously tried exactly that approach by bringing civil tort claims against Laura for fraud and intentional infliction of emotional distress in Owens versus Gillespie. As shown in the request for judicial notice, Mr. Woodnick lost that case, with the court granting summary judgment as to the counterclaims. This helps explain Mr. Woodnick's decision to bring essentially the identical tort claims in a different court, knowing this court lacks subject matter jurisdiction over claims of this nature.
Rob, I've been smiling all morning. Okay, my face hurts. my face hurts because since the stream started, and I'm also just intoxicated by the smell of Omar's tie. Don't worry, I am in a very good mood. By the way, so it's just my face. It hurts. Sorry, go ahead.
Oh, no, you're fine. The court applied the wrong legal standard.
Oh, of course they did.
Of course they did.
Why isn't he a judge? Why aren't you a judge then, David?
I don't know if you want that.
No, not at all. But I'm just
You
saying.
want him making rulings, like making actual judgments on?
No.
Oh, I'm just saying. As a general rule, parties who come to court seeking judicial assistance are not subject to a strict liability evidentiary standard. Parties who bring claims made before discovery has begun are never required to exhaust every possible avenue to confirm, verify, or double or triple check the veracity of their allegations before filing suit.
You mean like your client did? Who just puts whatever claims they want before discovery and they don't have
We're
to
not
do...
talking about his client. We're talking about everybody else. Quit trying to make it about him.
You're right. You're right. I forgot. I should have a page on only ties. Yeah.
It's gonna get its own like social media. It's gonna have like an X account. It's gonna have like an Instagram account. It's gonna post daily updates about how it feels.
Maybe we'll put googly eyes on it at one point.
Oh, don't do that.
I'm not gonna do that.
I was like, that leaves.
I don't have any googly eyes.
So I don't care if you did. On the contrary, the Arizona Supreme Court, like essentially every court in the United States, merely requires that litigants conduct some reasonable investigation into the facts and that they have an objective basis to believe their claims may be colorable.
Just a second. Monday, Wendy. Monday's when we'll finish up the Taylor Parker stuff, Monday afternoon. So mark your calendar for that. Sorry. Go ahead.
A claim is colorable when it has some legal and factual support, considered in light of the reasonable beliefs of the individual making the claim. The question is whether a reasonable attorney could have concluded that facts supporting the claim might be established, not whether such facts actually had been established. Okay.
All right. Okay. All right.
Boone versus
I don't know if Laura thinking anything she filed was reasonable is accurate. Because every reasonable person I know is like, nah, no reasonable person would think that, except apparently for her very reasonable lawyer who is smarter than all of us.
because we're
So,
stupid.
stupid,
To-
dumb.
To restate the correct legal standard, the question is not whether an allegation made in a pleading has actually been established before the case is brought, which is the incorrect legal rule applied here. Rather, the question is whether the party asserting the claim has some plausible basis to believe their factual allegations might be established.
I don't know about that.
Again, the Arizona Supreme Court has repeatedly and consistently found sanctions are not justified simply because a litigant asserted a claim that ultimately was not successful. That is not the proper standard and never has been. Instead, even under the more stringent provisions of the recent revision to Rule 11, a counsel is required only to make an investigation, which is reasonable under the circumstances that exist at the time of filing the pleading. The new rule requires no more than a good faith belief formed on that basis of that reasonable investigation that a colorable claim exists. The rule is not to be used to require counsel to offer proof of the pleading before discovery and before trial.
So is he saying that, like, well, I didn't have to do anything. All right. I thought this was all reasonable. It was on them. It was on
It's
them.
basically he didn't have to do any work to see if any of
Yeah.
this was actually true. He just had to believe that it was actually true.
Exactly.
And that if, that's all is required of him. Yeah, he doesn't have to
Exactly.
make sure he's not saying anything factual in court, because why would we do that?
Why would we do that? That's so silly. My only evidence is these 6 P tests she allegedly did. It's fine. That's enough.
It's like that falls under not my job. Okay. It's not my job. Okay. Here,
Okay.
in the post-trial judgment, the court purported to find Laura filed this action without substantial justification because, in the trial judge's view, Laura failed to act reasonably.
Mm-hmm.
In seeking prenatal care. And failed to take reasonable steps to verify her pregnancy.
And so, wait, hold on. He's saying this is unbelievable. Why would the judge? This is unbelievable. How dare she? Is that what he's implying?
It's what it sounds like.
Okay.
Specifically, petitioner acted unreasonably when she initiated litigation without basis or merit, without an authentic ultrasound, sonogram, physical examination, and in conjunction with a belief she passed tissue in July 2023. The court finds the underlying petition premature at best. Those findings and the resulting award of sanctions were based on a clearly erroneous application of the wrong legal standard. First, nothing in Arizona law requires a woman to have an ultrasound, sonogram, or physical examination or any other procedure before she may bring an established petition under ARS 25.
Right? Shocked. Or not shocked. You're not shocked.
Well, if
Yeah,
that's actually the case, then that law should be looked at.
That it absolutely should be. Absolutely should be.
That provision requires nothing more than a verified petition that alleges that a woman is pregnant with a child conceived out of wedlock and that the respondent is the father of the child or children. Second, the correct legal standard is not whether Laura acted unreasonably when she initiated litigation without basis or merit. That is purely erroneous legal rule. Okay.
Exactly, Negla. Who in their right mind would seek prenatal care when you're an autistic epileptic with one ovary who apparently gets pregnant very easy and high risk?
And has a lot of miscarriages.
A lot that she's not concerned about at all and doesn't go to the doctor for at all. Sorry, you're not winning us over, David. No.
No.
And trust me, you really
And-
did not want a jury. She'll find out when she goes to trial.
Oh, yeah. Instead, the question is whether at the time she filed this action on August 1st, 2023, did Laura have some basis to think she might be pregnant? I have a problem with that.
Mm-hmm.
Nobody files a paternity suit for parenting or whatever if you think you might be pregnant.
Exactly.
Right?
He's trying to save her ass, but it's not gonna. This doesn't make her look any better. So if she thinks she might be, then why didn't she go do the things that she needed to do to, have more evidence besides some pee sticks if she might believe she's pregnant? Like, it still doesn't work. It still doesn't compute, David, at all. And also, your client's a fucking idiot. So she's just a liar who lies. And I understand you're trying to bail her out here, but it just, it's not helping. Not helping.
No, because it doesn't make sense. Did Laura have some basis to think she might be pregnant and that Clayton might be the father?
No.
C. Boone. The question is whether a reasonable attorney could have concluded that facts supporting the claim might be established, not whether such facts actually had been established. Okay, maybe that is only the attorney's responsibility, but why wouldn't you want to make sure it has if you're going to go in front of court and sound like an idiot trying to argue it that it was?
Exactly.
I feel like you should have a little bit more pride in what you do, that you don't want to sound like an idiot on a mic. You would want to make sure you're arguing something you can actually prove. I have to question your I don't know what's the word I'm looking for. Just your ability to do your job and have pride in your job. Events which occurred after August 1st, 2023, such as the low 102 HCG test result some 2.5 months later in mid-October 2023, are completely irrelevant to that issue. Again, the relevant question is whether Laura believes she might be pregnant on August 1st, 2023, regardless of whether she miscarried later and regardless of whether she was, in fact, never pregnant at all.
Oh, my goodness. What?
Did you write that? Did you read
It's
that?
irrelevant.
And said, that sounds good. That's a great argument. It's completely irrelevant. That's what?
Oh my, these problems don't. Well, that's true, right? They do say stupid people don't know they're stupid.
Yeah, stupid people don't know they're stupid. Holy fuck.
Hello, Melissa. Hello.
How did you? I'm sorry. I don't know how you thought.
It's irrelevant.
Put that in there. Put that in there. Yeah, say that. That sounds good. That'll convince the judge. Ugh. It is an undisputed fact that before this action as filed, Laura tested positive for pregnancy on multiple occasions, including a surprise test taken at Clayton's residence. Clayton admitted in writing that the sexual contact with Laura might have resulted in pregnancy. He said this in his own words. It is also undisputed Laura asked Clayton to agree privately to a DNA test, which would have confirmed or not both the existence of the pregnancy and the paternity of the father. After
look, Melissa, it's Melissa's first time here for a live. She's late for here and her first time catching us on live. Thank you, Melissa. Happy to have you. Get a seat on the couch.
Welcome to the chat.
Oh my God, this is insane. Okay.
No, he's just so dumb.
So dumb. Well, here's the thing too. Even if she might believe she's pregnant, then if she might believe that, then you think she would reasonably go to the doctor to see. That's the thing. But okay.
That's what
we might all be preggers. I mean, I might be after wearing this tie all day, but that's all that matters, apparently, is whether or not if we want to believe in make believe land, which is wild. I believe I might own a home, so I'm just don't pay the mortgage until next month and see how Chase Banks likes that. Ford Motor Credit it is,
I mean,
right?
I believe I paid off my house. I mean, I don't need to have evidence that I just have to believe that I did.
Yeah, it's such a fucking stupid argument. Oh my God. It's
Yeah, I wonder how
embarrassing.
my electric company would be like, I believed I paid that last month. I believed I did, and therefore,
Right? I might
okay, whatever.
pay it, but it doesn't matter. Who was the expert that said Laura was 99% pregnant? That would be Dr. Medchill. Real name.
It doesn't
That guy.
matter that I didn't pay it. I believed I did.
Wendy's passing wine out to the chat. Thank you. It is Fukong Friday, so day drinking is celebrated. Which maybe I should open mine up, but I don't know. Maybe after I drink this wine, we'll see.
Oh,
Jan,
that'll be
Half
fun.
says Jan was also like, I believe yesterday. Oh my God.
I believe. Well, I believe I could fly.
Wow. Okay.
I know. I know. This is so painful. If you're sticking with us, you're appreciated and you all deserve medals because
You're all
this is
VIPs.
painful. Yeah, y'all are like the real ones, right? Like you're like the goats.
Right.
Which
But this is
I don't
also
want to talk.
important. This is also important to read because they are going to be filing appeals. So you kind of have to acknowledge that
I
you're going to go
know,
through it
I
to
know.
understand the
I'm
later
just
stuff.
saying
But
he's painful. His arguments are painful.
mhm,
His restating the same thing over and over again is so painful. His excessive
that it is.
use of case law is fucking painful. All right. It's gratuitous, okay? All right.
That it is.
So Clayton admitted in writing that sexual contact with Laura might have resulted in pregnancy. He said this in his own words. It is also undisputed Laura asked Clayton to agree privately to a DNA test, which would have confirmed or not both the existence of the pregnancy and the paternity of the father. After Clayton refused to voluntarily agree to testing, Laura filed this action to force Clayton to participate in a test.
Look, you got
Although
another
Laura
Louisiana native.
Oh,
Melissa is from
you're
Louisiana.
down the street from me. You are literally about 15 minutes away. I'm
Oh,
just
no
saying.
shit. Oh, no
Yes.
shit. That's cool.
She's like literally, I can go down. I mean, yeah, I know the excessive use of the word literally, but she's literally in the next town over. Like she's 10 minutes
Oh,
down the road. I'm
wow.
like, right. Yeah.
That's pretty
Like
cool.
it's down the street. I can go this way and be in one city and be in the next city in like 5 minutes. Like it's the same.
Oh,
So
nice.
that's funny.
Look at that. That's exciting.
We are so close, bestie.
Yes, relitigating what he already lost. And it's not even relitigating it in a good way, quite frankly. But okay.
All right. So, and now I just told you exactly where I live. Don't stop me.
Not quite.
Just teasing. Okay. So, although Laura maintains that she was in fact pregnant, applying the correct legal standard here, it actually would not have mattered if Laura was never pregnant at all.
Oh my
Indeed,
gosh.
right? Like it doesn't even matter.
The fact that like now he's just
It doesn't
arguing like,
matter.
yeah, that means he's like, fuck, yeah, she did lie about everything. But like, you know what? It's fine. Who cares? It doesn't matter. She could lie all she wants. It doesn't matter. Initially, she was right. Like, what? What? Like, I would not keep bringing up that my client may have made it all up and not been pregnant. Why would you keep bringing that up? Is all I'm saying. Why are you drawing attention to it? But okay. Okay, David.
Yeah, he's got what he does it all the time though. Every time, like I've said it before, I'll say it again. He constantly throws shade at her
Oh,
through
Laura,
all
yeah.
of his motions, where it's like, why, as her attorney, would you say that about your own client? Like, stop it. Stop putting that out there
Yeah.
consistently. Like he does it all the time. It's annoying. It's funny, but also annoying.
Like, I think he's bringing this up to try to get her out of those perjury recommendations, but like, I don't think it's helping. Like, it's not going to help anything.
I wonder if he'll show
So
up when she goes to court. I would love to see if he's like sitting there in the, in the church pews behind her or whatever in the
and
gallery.
some lady says she reminds me of a more competent Kim Blandino. If you don't know who Kim Blandino is, he was a lawyer, right? That was practicing in Vegas. And he finally has been labeled a vexatious litigant, if I recall, being up to date. It's wild. His stuff is always so weird and wild when he's in court, filing his own, because like he'll have his own court cases. It's just, if you need a weekend, just YouTube Kim Blandino. You'll be on a while. Oh, he's not a lawyer. Okay. It's been a while. It's been what, like 3 years probably. But wow, he was something. Yeah, and using lawfare runs up major bills for the unfortunate target. Exactly. And that's what she does. She practices lawfare. So like, come on. Let's be serious, David. Stop it.
Nobody likes you, David.
Nobody likes you and nobody likes Laura. She's
We
a
don't
liar,
like
liar,
Laura
liar.
more. I don't know. I can't decide who I dislike more.
Well, I definitely dislike Laura more. Because I do find David funny sometimes in his things.
We
Though
do appreciate
he's not
his
great.
humor.
But
But he beats a dead horse, and I just can't really. I can't give him a pass for that.
Agreed.
All right.
Bye, so well hidden. Have a good one. Happy weekend to you as well. Thanks for joining
Although
us
Laura
today.
maintains that she was in fact pregnant, applying the legal standard. Wait, what's behind
sorry.
the couch? Applying the
Correct.
correct legal standard. Correct legal standard here, it actually would not have mattered if Laura was never pregnant at all. Indeed, one of Clayton's arguments, albeit one which lacked any factual basis, is that Laura may have taken epilepsy medication that produced a false positive. Okay.
That wasn't even one of his arguments. That's just something he said during a minute. That wasn't argued in court. Was it? I don't think so.
No, I think it was. I think they did bring up, I don't think they brought up that Clayton said it, but they asked the doctor, were there any meds that someone could take that would?
Oh, yeah, they did ask. Yeah, they did ask. Did they ask both
I
of
do
them,
remember
right?
that.
MedChill
I
and
think so.
because MedChill said no. I think.
Yeah, and I do remember that she said
Or
she named
yes,
off
whatever.
some and said some
Okay.
cancers because I was like, oh yeah, well she claimed that, and I know I think going through. There's a lady on TikTok right now. I don't know if anybody else are on the TikToks. She's like an older lady. I mean, she's not an old lady. I don't want you to get that picture. She's an older lady. Like she's, probably a little bit older than me. Her husband has a vasectomy. She has a positive pregnancy test. She went to the doctor. Her tests are coming back positive, but they keep doing ultrasounds and there's nothing there.
Mm-hmm.
And they keep doing blood work. And I think her HCG levels are like 26.
Oh,
But yeah, they're coming up, but they're like, they can't see anything. So they don't think she's pregnant. Yeah, she's 51. So you see her on TikTok. Yeah. And so like, I've been following her going, because she's like, we don't know why my tests are coming back positive, but there's nothing there. So I've just kind of been following her on TikTok to see like what they finally say.
Gosh, wouldn't that? Oh,
yeah.
Hopefully that's not, cancer, because cancer can do that. Oh.
I said older than me. She's a little older than me. I am 44, so older than me. That's why I said she's not an old lady. She's just older. She's older than me.
That's true. They did bring up all the other possible reasons it could do that when questioning the witnesses. Yeah, that's true. I remember that now. Oh, hello, Pancake. Pancake says that happened to me, but I was younger and I had a molar pregnancy. Oh. Yeah.
That's so
Sorry
wild.
about
The
that.
human body is so wild.
It is.
What happens, the different
It is.
things.
But you know what? I bet y'all did, and I bet what she did. She went to the doctor.
She went to the doctor.
and
Huh.
and got an
Well,
ultrasound that was like there
yeah.
wasn't there. It wasn't like, well, I'm 50, something. I'm probably not pregnant, but I believe I am, and so I'm just going to tell everybody I am. Like, nah, nah. Mary Smith, thank you for or for noticing. Thank you. Omar smells delicious. I've been intoxicated. It's too much. I'll be honest. It's too much.
Text packets listening in the shower. I feel like I got brought into some private
It's
sanctuary or something.
all right. We're all besties here. You can listen to us in
We
the
just
shower.
shower together.
Fine. Hello, Mary. Good morning to you.
Oh Lord.
All right.
Okay, so okay, where are we at? Laura may have taken epilepsy medication that produces a false positive result, although Clayton's medical expert offered no testimony to support this. And although Laura's medical expert directly rejected this theory, it is theoretically possible that Clayton was right. Perhaps Laura was never actually pregnant. See, how are you helping her here?
That whole sentence does not appear. Both the doctors were like, nope. And he's like, maybe she wasn't. I don't know. I don't know. But it don't matter. Like, what are you doing? Okay. Oh my.
Perhaps Laura was never actually pregnant, but unbeknownst to her, one or more of her medications caused her to receive a multiple false positive pregnancy. You know what would have helped that day? A doctor appointment.
I know that a reasonable person who might believe they're pregnant would do. Again, I mean, I'm just saying.
It's like your argument makes me go, okay, well, that's your argument. Go back to the first argument. Go to the doctor. Like there's
Mhm.
every argument you make to one of the findings of fact that you disagree with leads to another argument. Well, if she had gone to the doctor, she would have got the answers to all of those fucking questions.
Right? And we wouldn't be here. Oh, but that's right. It was never real to begin with. There's a reason why she didn't go daybed. Anna some lady says my ex-girlfriend was testing positive for a while and even started lactating, and then it just stopped. The body is
Wow.
weird. Oh, that's
The,
interesting.
yeah,
Oh my
it is
goodness.
weird. In that
Yeah.
stage,
Oops.
in that where? Okay.
In that situation.
Yeah, no, I don't. Did I finish the one before that? Okay. In that
Yeah.
situation, there would be no basis to sanction Laura for unknowingly filing this action based on a freak medical scenario of which she was completely unaware.
A
Indeed,
freak medical scenario.
it's freak.
That's
It was just a freak in
clearly
nature.
the right wording
She's
for
a
it.
freak in nature. Freak in nature. Got it.
Uh, uh,
That's is that a legal
That's
standard
true,
or an
half-assed.
argument?
Medical anxiety is a thing. I have it. I
Oh yeah.
have a big problem. Uh, but she did go to urgent care for so what
Bet.
are you doing, Laura, right? Like, you have no
She
problem
managed she manages to go
telehealth.
to the doctor when it suits her. She goes to the hospital when her stomach is bleeding so she doesn't have to go to court.
Mhm.
She goes to
The
she
epilepsy special
manages to get over
program.
that anxiety when she needs to, when it benefits her.
Right. No, I get what you're saying, half-assed. Well, I mean, we all know, like, she's full of shit. But, yeah. Yeah. Hmm.
In that situation, there would be no basis to sanction Laura for unknowingly filing the action based on a freak medical scenario on which she was completely unaware. Indeed, the undisputed evidence at trial showed Laura attempted to investigate this possibility of a false positive test by discussing that issue with her doctor before this case was filed. Did she, though? I don't think so. You proved none of that.
Mm-mm. No, I don't recall that.
The respondent suggested that the positive test was a result of petitioner's epilepsy medication. Petitioner emailed Dr. Glynis Simon, MD, from Barrow Concussion and Brain Injury. So the subject of the email is pregnancy and seizure med. Here,
Because
the
I know
undisputed.
I go to the brain doctor when I'm pregnant. See what they think first and
Well,
foremost.
because it was the seizure med, she was asking the seizure doctor if that would give her a positive pregnancy test. So therefore, she says that that's the adequate, due
Right.
diligence to talk to a doctor. And I disagree. Well, if you
No.
suspect you're pregnant, go to the fucking doctor and let the doctor tell you whether you're pregnant or not, or why you know,
The
if you're
lady
not pregnant,
doctor.
why?
I mean, just saying.
Here, the undisputed facts are that Clayton made a written admission that he saw at least one positive pregnancy test, the one Laura took in front of him on June 19th, 2023, leading him to question whether Laura may have taken medication that caused false positive results. Before this matter was filed, it is undisputed Laura discussed that exact issue with her doctor in an email sent on June 28th. Even if the medical advice Laura received from her doctor was wrong, and there is no basis to support such a conclusion, and even if Clayton's theory was right, that Laura's epilepsy medication caused a false positive result, and even if Laura was never actually pregnant at all, there's simply no evidence to show that she knew all these things before this action was filed. Thus, if the trial court had applied the correct legal standard, it could not have properly found Laura lacked a good faith basis to think she might be pregnant when this action was filed, even if that belief was incorrect. Oh, come on, my friend. I don't. The court misapplied ARS 25. The final judgment awards fees under ARS 25 based on finding of unreasonable litigation conduct on Laura's part. This is plain error because ARS 25 does not apply to paternity proceedings. It only applies to the cost and expenses of something else, and I'll tell you in just a minute. My stuff is missing.
Hold on, I can scroll down. Sorry. I just had to go to the bathroom, but now I'm getting something to drink. So that's fine. Whatever works for you.
Wait, where are you?
Under that big heading of the next one.
Okay. The final I don't even know where I was. The finding of unreasonable litigation conduct on Laura's part. This is plain error because ARS 25324 does not apply to paternity proceeding. It only applies to the cost, expenses of maintaining or defending any proceeding under this Chapter 3 or Chapter 4, Article 1 of this title, blah, blah, blah. David, you're killing me. The correct statute for a fee award in a paternity action would have been ARS 25, which contains essentially the same standard. The court may order a party to pay a reasonable amount to the other party for the costs and expenses of maintaining or defending any proceeding under this article. For fuck's sake.
Okay.
But here, the court erred as a matter of law because ARS 25809 only permits an award where a party has engaged in unreasonable litigation conduct and such conduct necessarily caused the other party to incur unnecessary fees and costs. For the purposes of this subsection, costs and expenses includes attorney fees, deposition costs, appellate costs, and other reasonable expenses the court determines were necessary.
Sorry, I got a vodka drink. I'm out of juice, so it's Sunny D because I'm an adult. But I was like, you know what? It's Fukong Friday, and David is making my brain hurt. So well earned.
My brain is bleeding.
Hi, G Daddy. Hope you're doing well. We miss you. Okay. Sorry. All right.
Here, essentially, every penny of legal fees requested by Clayton involves work done after Laura motioned to dismiss this matter with prejudice on December 28, 2023. By moving to dismiss with prejudice, Laura offered to give Clayton all the relief he was entitled to, thereby obviating any need for further litigation, as was explained in Laura's motion for judgment on the pleadings, filed May 10th, 2024. Substantial legal authority supports the conclusion that sanctions and fees are not available as a matter of law once a party offers to withdraw their claims with prejudice. Defendant's basis for even threatening to seek Rule 11 sanctions based on the allegedly frivolous pleadings let alone formally move for such sanctions. It evaporated, like it just evaporated. On March 2nd, 2023, when counsel
Magic.
offered to stipulate to a dismissal of the entire case with prejudice. She just wanted it to go away. She didn't want to be held like any accountability for all the shit she did leading up to it.
Hi, honey.
Hey, honey, I'm home.
We would never.
Okay. The underlying purpose of the safe harbor precludes a movement's ability to move for sanctions, given the offending pleading had already been withdrawn via voluntary dismissal. Whatever. Once Laura moved to dismiss with prejudice, there was absolutely none, for further litigation as to any paternity issues within the family court's jurisdiction. Of course, Clayton refused to accept this because he did not care about any paternity issues. He instead wanted to use this action to continue litigating tort claims that were effectively identical to those Mr. Woodnick brought. Oh, he's throwing spears at Woodnick.
Yes, he is.
You didn't have lunch with me, sir.
Or go to Golf and have nachos.
Oh, he's so sad.
He's still upset about it.
He's so sad. Mr. Woodnick brought and lost on behalf of Mr. Gillespie, but Clayton's decision to unlawfully misuse a family court proceeding to litigate a pseudo-civil tort claim does not mean that such work was necessary to resolve the paternity claims within the meaning of ARS. We're only on B, guys. Factual errors. Multiple subparts of Rule 83 permit mistakes in a judgment. Well, I can tell you a bunch of mistakes you've already made in this one, but let's not. I'm going to write a 32-page document on all your mistakes.
You're going to have to ask for a page extension.
Yeah.
Don't forget your motion for more pages.
Multiple subparts of Rule 83 permits mistakes in the judgment to be corrected for various reasons, such as where the court did not properly consider admitted evidence, mistaken, overlooked, or misapplied uncontested facts, or where a finding of fact is not supported by the evidence. Fuck this case law. I'm so over it. Here, the judgment I'm sorry about cussing. You're so
funny.
Oh, well, I feel bad because I know, but I don't know if people are listening at work, and I feel bad. So,
well, with
their kids are in the room, so I do try to. It's the day.
That's fine.
Show.
We're not friendly.
Like, I'm so over this guy and his case law.
Yeah, Say Chief says he won't be able to attend the criminal trial because he is on the witness list, which is wild. I mean, I've seen a few trials where previous lawyers have had to go up and testify.
Attorneys are the worst witnesses.
They are. They are. So, but they have to be, right? Like, I mean, I would say it's uncommon to have an attorney on the witness list, but I have seen trials where attorneys for example, the Paul Canero one that we did in January, February. I believe they had one of his a previous lawyer. Maybe that's not the trial. Anyway, I have seen it quite a few times. So it's not good if their former lawyers are going to be on the witness list. I'll tell you that. That's not good. So
the words are a complete pain in the ass, and I really appreciate all of your thoughts and prayers and good vibes and whatever gets you through the day.
We're gonna need it. I'm drinking for both of us. It's fine.
I wish I drank.
Wink says
maybe I should start.
Wink says the whole arrangement of sanctions pisses me off because Clayton asked for them in his initial handwritten response. So him claiming it was like too late, and since she tried to dismiss it, he wasn't entitled to make them. Such a crock of shit. I agree. I agree. Also, I agree to this. Chief Daddy, thank you. I always have the best ideas. No, I'm just,
Oh, I don't know
I'm
about
just
that.
kidding.
You should hear some of the ideas. It's
Do,
like, no,
do you
no, we
need
shouldn't.
support drinkers? Yes, we do for Buffy because Buffy doesn't drink.
Buffy
So
doesn't drink for a multitude of reasons.
I'll tell you what, I guess you get the tie next because you're about to be intoxicated when you smell this thing. I'll tell you what. Oh, calm down. I'm fine. I'm fine.
Accordingly, those errors should be corrected as follows. 1. Page 2 of the judgment contains the following findings. Laura Owens, petitioner, filed a pro per petition to establish paternity, legal decision making, parenting time, and child support on May 20th, 2023. This finding is factually incorrect. This matter was filed on August 1st, 2023. Sir, you dated something like 6 years into the future or some
Yeah.
shit.
2029, just merely 5 pages ago. But sure, sound off, Queen. Sound off. I mean, as soon as we read that, I pointed that out too. I was like, that's not, that was point like obvious number 1, number 2. And I was like, that's not
Yeah.
even right. So, I mean, I get it. He's pointing it out, but also like, sir, then double check the
I'm
1 year.
terrible with dates. I wouldn't have noticed because as soon as I see dates, they just fall out of my brain.
That is
I don't
true.
know what happens. They don't stick here. They just fall out of my brain.
Yes, half-ass fashion. Please do.
Actually, I think it's anything that includes numbers. It just falls out of my brain. Okay, so this is factually incorrect. It was filed on August 1st, 2023, not May 20th, 23. May 20th, 23 is the date the parties engaged in sexual contact. Page 2 of the judgment contains the following finding. On October 6, 2023, petitioner filed for an ex parte order of protection in this court. After hearing the order of protection was affirmed, the same day the Rabgen results indicated little to no fetal DNA. As to the last sentence of this finding, i.e. that Rabgen results were received on the same day, October 6, 2023, the finding is unsupported by any admitted evidence. Page 2 of the judgment contains.
No, I don't see how.
He
They're gonna.
has issue with the same day. Right?
I'm pretty sure they were the same day. I don't know. Let me pull up my timeline while you're talking. It's fine. Oh, that's on my old one. That's okay.
On page 2 of the judgment, page 2 of the judgment contains the following finding. October 25th, 2023, the parties appeared before Commissioner Duty to determine the validity of the contested order of protection. Petitioner's abdomen again appeared swollen. Yeah, that happens to me too when I eat a lot of bread.
Mm-hmm.
During
well,
this
you know the
hearing,
gluten makes the crazy, guys. It's the gluten.
I do love carbohydrates. They do not like me. During this hearing, she testified to the validity of the sonogram sent to the respondent, the media, and a Dropbox on Reddit, and further testified the parties were having a son. She later testified she believes she was having fraternal twins, one boy and one girl.
Because that makes sense.
One boy, one girl. Isn't that a song? It is a song.
Which they wouldn't even. So if she allegedly passed these twins and miscarried on the 23rd, they would only been like 10 weeks. They wouldn't have known what each one was without some testing being done. Because I don't think you.
Well, yeah, because you
grow
would have
your
a
genitals
test that
yet.
came back.
Exactly. Like, so it doesn't make sense. You're still saying stuff. It doesn't make sense, David. So, and a reasonable person would believe. So there's that. But okay.
As to the finding, she testified to the validity of the sonogram sent to respondent, the media, and the Dropbox on Reddit. This finding is contrary to the evidence and is not supported by any admitted trial evidence. As to the last sentence of this finding, that Laura testified before Judge Duty that she
Dude.
believes she was having fraternal twins, one boy and one girl. The finding is factually unsupported by any admitted evidence because Laura never offered such testimony before Judge Duty. I just like to say Duty
Duty.
because I'm an adult. Page 3 of the judgment contains the following finding. December 6, 2023, a second Ravgen test confirmed little to no fetal DNA. Also, as to the date of the second Ravgen test, December 6, 2023, this finding is factually unsupported by any admitted evidence.
But you're the one that was saying, oh, this Ravgen thing, it's all Laura's idea. It's all so you didn't submit evidence. I don't know what to tell you there. Again. So, okay. All right, David.
Page 3.
He doesn't have to, I forgot. He doesn't have to submit any evidence.
He doesn't have
at
to.
all.
He just has to believe that it exists. If you
As the
believe the
plaintiff.
if you believe the evidence exists, it does, and therefore you have to do nothing else. Page
Right.
3. Oops, sorry. Medicine.
Oh.
Hold on.
It's 1 o'clock.
Page 3 of the judgment contains the following finding. December 28, 2023, petitioner filed a motion to dismiss petition to establish paternity, legal decision-making, parenting time, and child support with prejudice in conjunction with a notice requiring strict compliance with Arizona rules of evidence, thereby invoking ARFLP Rule 2. Petitioner cited the basis for the dismissal that she is not now pregnant with respondent's children. The motion was denied as the issue of attorney's fees, costs, and sanctions remained.
I'm disappointed too, Echoes. No, I'm just kidding. Not at all. I completely respect people that don't drink because there's a numerous of reasons, right? There's health
Are we having a
reasons,
discussion about not
all
drinking?
that.
Am I missing a whole
Well, no,
entire
it's
chat?
No. It's just that Jeep Daddy and I are the drinkers where you and Echoes are not the drinkers.
Well, I'm not the drinker because
And that's how we all balance our duos out. You need that. They're
partially due to my religious beliefs and also partially to I have family members within my household who are alcoholics in recovery, and I don't drink to support them. So
absolutely.
I have a multitude of reasons.
I don't care if people drink or not. There's again a myriad of reasons why someone may not to. So, but that is how the balance of the universe occurs. Exactly. Like Jeep Daddy and I both need our Buffy and Echoes when we have been drinking to be like, all right, you guys. Hello. So Danny goes, yes, 1 boy, 1 girl, 2 hearts beating wildly. Yes, to put it mildly, it was all one big lie. It was. And a lie that doesn't even make any sense for her timeline. So there's that. That's true. That's true. Oh, goodness. Okay, back to this. Ugh, hurts my brain.
All right. Okay. I gotta. As to the last sentence of this filing, i.e., the motion to dismiss filed by Laura on December 28th, 2023 was denied. That finding is not. Yep, and that finding is not supported by any admitted evidence because, and it overlooks or misapplies uncontested facts. The docket in this matter reflects that on January 25th, 2024, the court issued an order granting Laura's December 28th, 2023 motion to dismiss with the following language. Petitioner advises she is no longer pregnant and has filed a motion to dismiss. While the court will grant the motion, the issue of sanctions and attorney's fees remain. Page 4 of judgment contains the following finding. At trial, petitioner testified that the parties had sexual intercourse and that it was rape.
Oh my God. Are we still spouting this bullshit? Are you kidding me?
I think is he gonna say that That's not an evidence? I mean, I don't know.
I don't know, but like, what are you? I don't even know what he's gonna say next. But like, what? Let me guess. She believed she was. So she. What stupid shit are you about to say, David?
This
'Cause
finding
this makes me very, very
misstates
mad.
the evidence. Laura asserted both at trial and before that Clayton briefly inserted his penis into her vagina
Oh no.
without her consent, and that this conduct may fit the technical definition of rape, but that she did not intend to accuse him of rape, and that she did not personally consider his conduct to be rape or any other crime. Whoa, whoa, whoa.
Oh. Mm. Mm-mm-mm.
So, like,
Mm-mm-mm.
I think it fits the technical definition, but I'm not saying he did that. Okay, guys.
No.
And
It's doing what shitty fucking people do, right? Which is spread, gossip or say something and be like, "Well, I did. I didn't mean it." Like, I don't have anything to back. But no, like, it's not like that. Even though now I've announced it to the court in a deposition, the whole world knows. But no, it's not like that. No, anybody is just going to hear, "Oh, he raped her." Like, shut the fuck up, Laura. Shut up. It never happened, and you know it. And it pisses me off so much. It's gross. She's so gross. So gross. Because she lied about this to cover up her own lies instead of just being fucking honest and walking away. But no. So, me too, Wendy. Me too. It makes me so mad. Because listen, here's the thing is when this first came out, if anybody hears this part, but they don't know the context of everything else, and all they hear is like, well, yeah, she accused him of raping her, but they don't get the rest of the information, they're still
Mm.
going to think that's what happened. And so
Mm.
that's why it's incredibly dangerous what you insinuate and put out there. And you can't be like, oh, no, I didn't mean it. No, you did. That's why you said what you did. Stop it. Stop the games. Because then it wasn't just in the deposition. They bring it up in a filing after the fact. And it's disgusting. She does so much. That's disgusting. I hate her so much. I do. I don't
flipping the
care.
table.
Flipping the table over this bitch. I'll tell you what. Mm.
All right. Page 4 of the judgment contains the following finding. Petitioner testified that she has been pregnant 4 times. Each time, the alleged father believes she fabricated the pregnancy and doctored medical records. As to the second sentence of this finding, the finding was not supported by any admitted evidence. In addition, the specific question regarding the beliefs of other third parties was the subject of an objection as to lack of foundation, which was sustained. Okay. What's your point, David? Page
Exactly.
5
Mhm.
of the judgment contains the following finding. In the something to consider email, respondent maintains that the lack of sexual intercourse would preclude him from being the father of the fetuses. This finding is not supported by and is directly contrary to the admitted evidence. In the something to consider email, respondent specifically stated exactly the opposite of the court's finding, that the lack of sexual intercourse would not preclude him from being the father, because respondent admitted there was sufficient other sexual contact that pregnancy was possible, even though he believed the likelihood was very low.
Oh my, is she pregnant or is she not, David? You're going all over the place. Which one fucking is it? All right. You're sticking with
He's
she might believe she wasn't, but she could have believed she was. And now she's saying, well, she definitely could have from, the finger banging and grinding. Like, what are you even saying about your client? It's all over the
I
place.
checked, fingers didn't impregnate you, but what do I know?
I get some pre-com on there. You know how it goes. Like, can it happen? Yeah, but the likely, like, oh my God.
I mean, I don't know, because I feel like a lot more people would do it that way.
Exactly. And the pull-out method isn't, super foolproof, okay? But like the likelihood is still relatively small. And you don't know how good Clayton's spermies are. He may not even be, having a full lineup of his basketball team. I don't know. We don't know because that's quite a journey. If so, we don't
He
know.
might have unleaded gas. Who knows?
Who knows? Like turkey basting yourself, which is a real thing. I mean, they have the insemination kits at Target. I've seen them. But yeah, you had to make dinner for your father-in-law. He's very dramatically not feeling good, so I'm bringing him dinner. Okay, well, probably don't let
What
him
are we
listen to this.
making?
What are we making? Because I'm kind of hungry.
I know. What are we?
Yes, you would need some like super duper fucking spermies to swim that distance. All right, because it is a distance. Can it happen? Sure. But a full lineup, right? No one's sitting on the bench in this game. See, I do know some sports terms, mostly basketball.
You know a lot of sports terms. Be able to play that one in there. Yeah. I mean, what are y'all eating for lunch? I need ideas. I mean, I'm not going to take any ideas. I'm going to eat the same shit I eat every day. But I want to know because food porn. I like food porn.
I want like some fancy schmancy like raviolis.
I've been on a diet since February, so like I like food, but I can't eat it. So like I want to see what everybody else is eating.
Also, I just realized the color of your shirt today because it wasn't dark. I just realized that. I like that color on you, by the way. Looks very nice. You're welcome. You don't wear a lot of colors sometimes.
You don't.
So
you do a lot of black.
Oh, you made French bread pizza?
Ooh, that's good.
You're having water.
Like homemade or like the kind you put in the oven. Like after I had like my last baby, that was like what I wanted. Even after I brought him home from the hospital, I wanted to eat that. But that got me in a lot of trouble and thus the diet.
Gita says, not an excuse or anything, but I'm sure Clayton's pullout game isn't quite what he may claim, but still, it's got to be in the right zone first. Yeah. And again, it takes two people and parts working correctly for, like, it is not easy. Like, everything to get pregnant is so hard. There's a reason why people struggle with infertility and getting pregnant because it is literally a small window where everything has to go perfect. Your body temperatures, everything.
And I know it's so small. Amazing anybody gets pregnant when you
really is
everything that has to happen.
It absolutely is a miracle that any of us we're even here because it really is a small window of time. The body temperature has to be correct. Like just so much goes into it, especially when you're trying to, you don't even know that until you're trying to get pregnant. And then you're like, well, damn, everybody made it sound like I could just get pregnant if my legs were out. Like, what do you mean it's this hard? And so it really is like this much of a margin to get there. And both, all players need to be starters. Lots of basketball references. That's the only one I got. So
yeah, you're doing a lot of sports talk. I'm getting the ick.
Just the basketballs.
But I'm not seeing food in the chat. I just want
Mary said yes. Mary said yes.
Homemade sauce,
pizza, French bread pizza. I want some raviolis, babe. Where can we get raviolis?
I have spaghetti in the crock pot, like spaghetti sauce and meatballs. I did it before we started the stream because I'm not gonna feel like cooking after this. So yeah, that's what they're eating tonight. But I'm gonna eat chicken, rice, and green beans like I always do.
Cindy's I'm eating a Lebanon bologna sandwich. Only people from PA know what that is. That's true. I don't know what that means. And I'm a next door neighbor to Pennsylvania. I also do not like bologna. No, thank you. But tell us what it is. I've never heard of it before. I mean, it's pretty wild. It's quite impressive. Hello, Toadette. Good afternoon to you. Hope you're doing well today, babes. Anyway.
Cinnamon roll is so good.
Oh,
I
cinnamon
love
rolls.
cinnamon rolls.
I got those in my fridge I can make.
I know. I got the ones in the can. They pop. Not
I'm
the
gonna
little ones,
make.
the big ones that actually have a spin to them. Because if you get the small cinnamon rolls, it's like a biscuit with brown topping on it. And I'm like, what the fuck is
Mhm.
that? You need the
Air fryer
actual ones with
shrimp.
spin.
Let's get married, half-ass fashion. Air fryer shrimp. I love it. I love it. Well, frequency adds to the pregnancy thing. Yeah, but you only
It
got that
does,
small
but it
window.
doesn't. You're
You gotta
only supposed
bang
to
like
do it.
every 15 minutes.
It's
I
every
know.
other day. If you do it any more than that, you don't have a chance to replenish your load.
Yeah, that's true.
Because that's what the
That's true.
doctor's instructions were to me. It was every other day.
And that ended up working for you, right? Or did you go with
No, it
in
did not.
vitro? I don't
It
remember.
did not. In fact,
With
it did not, in fact, work. No.
baby Buffy.
No. Can you hear
Mm.
me?
Yes,
Okay. No, it did not,
it
in
didn't
fact,
work.
work. No. Did not.
Replenish what load now? The exact one you're thinking.
Yeah.
Exact one you're thinking.
You
So that's why.
gotta reload.
And so that's another thing that's really infuriating about this case is a bunch of people talking about shit that they don't actually know anything about. And by they, I mean Laura and David, and they just think it's all how things happen. It's like, no, you could actually not be more wrong. So, anywho's, where were we?
Yeah. For us, no, it didn't actually work. It was like we just stopped, and like it wasn't for like I don't know 2 years that I got pregnant. We just gave up.
Yeah.
Yeah. After all of the freaking medications and crap that made me a very horrible person to be around.
Right. Right. Oh, smoke update. It's not great. It's still pretty heavy out there. I haven't really opened the door. My dogs haven't needed to go out, which is good. It's pretty bad in Ohio that Elbow Feet's job. Well, you know how I was telling you last night in DMs text that I was concerned about Elbow Feet working today out in that.
Mm.
Well, his work canceled at first because he's like a utility locator, right? So he's always working outside. And so last night they canceled all the northern people's day at work and was like, nope, you can't go. And then this morning when he woke up, they were like, no, nobody's working today. It's not healthy to be outside. So, which is nice to have a company care. I don't think so many others do, because this is kind of unprecedented. This has only happened like 2 years ago, to the best of my knowledge. We've never had this kind of thing happen. Um, but so it's good. It's good in the sense that we're inside. We don't have any plans to go outside. Also, if you are in this and you go outside, please use something to cover your mouth, a mask, a shirt, something, because most people don't realize that, like, let's say you're in a house fire, it's not the fire that's going to kill you. It's the smoke that's probably going to kill you. And while there's think about it, there is so much in the air that it is covering several states that you would think it's clouds or fog. That's how thick it is. So please, 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 if you do have to go outside, cover your mouth and breathing, because it absolutely could fuck with you, and you don't want that to happen. So no, it's not just the California wildfires, but yeah, it's in Canada and it's covering like all of Wisconsin, Michigan, Ohio, Indiana, well, parts of Indiana, and then I think it's made its way into Pennsylvania at this point. But all of that at once, that's how much smoke is occurring right now from that wildfire, which means it's a massive wildfire. So everybody up there trying to put it out. Oh, I hope they do. I hope they do. So it's wild. Um, so I'm probably gonna feel like shit later, to be quite honest, but that's okay. Because I started feeling like weird. Because earlier in the afternoon, I told Amos, who lives in Michigan, I was like, no, it's not really down here like right now. Like it's overcast, but like humid. She was like, it smells like smoke. And then after my show last night, I went outside and I was just like, oh my God, it smells like a campfire. And I had started feeling like getting a headache and stuff. So I'm just, if it's happening during the weekend, that's good because I don't have to cancel anything. So, um, but yeah, please be cautious. You're in Maryland now and we had smoke. Yes, more is on the way, babes. I'll tell you that. Just protect yourself outside. Who cares if people call you dumb for covering a face mask or whatever? You just never know. And I know it's way worse than where I am, like up in Wisconsin and Michigan. It's crazy. So, Lainey said yesterday was awful here. Today it's clear, but we're heading to Pennsylvania, where they were yesterday. Now, I've put pics in Discord. The sun looked like it was the second sun on Tatooine. Oh my God, that's so funny because Text Packet was talking about the moon or something in Hellville's chat last night. So I messaged her on Discord, like, what do you mean the moon? I can't see the moon. What's the moon like? And she was sending me photos. And I told her, I was like, oh my God. Didn't I text? I was like, oh my God, that looks like Tatooine. And she is not on that side of the UK of America. So I know, right, girl? That's so funny. Show the pic. Okay, yeah, hold on. Let me download it real quick because Buffy stepped away. So that's fine. We'll give her we'll take a little side quest. This is the one she sent me last night because we're weather nerds. And I was like, what do you mean the moon's looking weird? I can't see the moon. And she was kind enough to share her pictures with me. Let's see. Okay, so then I need to come over here and I need to do this one. There we go. So that's the picture she sent me. Like that was her favorite one, if I remember right. Right, Tex? Because you're getting smoke stuff going on too. But she sent me this, and my comment right after was, "It's like you're on Tatooine." We are such nerds. We are all nerds. How do I get in this weather nerd group? Well, you can be on Discord. That's where I hang out. Some of us are quite the weather nerds, whether it's on the Courtyard, which is our Discord. We talk about stuff everywhere, all of the things. Right? That's so funny. Is it terrible in Minnesota too? Oh no. I wasn't sure. I actually don't know where the fire's currently going. I just know Canada because of the downwind. It's in Minnesota too. That makes sense. I wasn't sure if you were on too far on the west side of it or not. Oh, seriously, it's really, really bad. Yeah, that was the least smoke filled picture that she had where she is. But that's so funny because we're all like, yeah, yes, it is Tatooine, right? Oh my God, we're so nerdy and I love it. It looked like haze, but well, you said you're in Maryland. It's coming, girl, because that's it. I just thought yesterday was like a humid, overcast day because I live in Ohio. Which, fun fact, if you don't know about Ohio, we have what are we like number 3? Or I think we're like number 3 or number 5 of the most overcast days in the United States. Like, you know how you hear about like the Pacific Northwest doesn't see the sun? We don't either. We don't either. I think it was, I want to say 171 days of sunshine. Fun fact. And you wonder why people from Ohio are so depressed and crazy. We'll go a whole month without like seeing the sun. Not that it's like pitch black, but it's just overcast. I call it Ohio gray. It's a real thing. Doesn't matter what time of the year it is. Like I'm not going to see the sun for like 4 days at least. So that's fun. That's why I have one of these handy dandy sad lamps, right? That are supposed to help you make you feel better when you live in a place like I do. And I don't know if it helped, if it was placebo or what, But I'll say that my SAD was not as strong this year as it normally is. So I don't know though. We'll have to see year 2 to compare my notes. But yeah, Sky Nerds, right? I love it. Because I was like, what is she doing? I know, right? You're waiting to see what your husband wants to eat when he's done with his colonoscopy. Oh, I hope that went well. He wants In-N-Out burger? Yeah. Mary, no wonder the raccoons do meth there. I know. They don't see the sky. They're sad little depressed raccoons. What are you gonna do? Um, but yeah, you can smell the smoke as of last night here. So it's not great. You can smell it in Rhode Island. Wow. Oh, crazy. You use one of the sad lamps too, and you said the same thing. Like maybe it worked. I did. I don't know. I'm gonna need some more yearly data here. But it did make it worse. So, but there was also a lot of different factors in my life this past winter to be like, well, because keeping yourself busy, having something that you need to do does help combat depression to a certain degree. It is not a cure. Okay. It is not a cure at all. But so I don't know if it's entirely the lamp, but it is the first winter that I've used the lamp. And it's the first time I didn't go into like a multi month depression that is bad news bears when I'm there. So I think it worked. I don't know. We'll see. Don't don't mistake the smell of smoke for having a stroke. That's true. But trust, like it smells like a freaking campfire outside, which I love the smell of bonfires. I don't know. A lot of people don't, but I do. But I don't want this much. I mean, enough to blot out the sun. That's significant to be able to do that and cross those distances. So, all right. Well, Buffy's back. So we're done talking about weather and Tatooine now. That's what we've been talking about. So there's that. And
I know. I figured while y'all were talking about that, I'd go pee.
that's fine. A little side quest, a wonderful side quest. Tex, thanks for letting me share that picture of your beautiful, amazing sunset last night. And she was sending them to me. It's like what, 11:30 at night or something, my time. Well, the conversation started earlier than that, but I was just like, man, why is it sunny out? It's dark here. And then I was like, oh yeah, time zones exist. Oh, we're so pretty. All right, where were we? Even if it's placebo to me, that means it does work on some level. Agreed. Agreed. All right, where were we? I think we were somewhere. In this something to consider.
No, we're past that.
We are past all of this.
No, I don't think we're at the highlighted section. I didn't read that.
Okay.
Considering you only performed oral sex on me, I know vaginal. Of course, it's going to be this.
Vaginal.
The vaginal penetration.
I like vaginal.
Penetration. My vaginal penetration. Vaginal. I don't know if anybody's listening outside my door, but my husband's gonna be like, "Are you having a stroke?"
Right? Is it smoke or is it a stroke? Which one is it? Vaginal.
It's vaginal penetration. Hey, I'm from the South. We're not known for our education down here. The chances of you being pregnant seem considerably low. Although, again, maybe rubbing up against one another allowed a sperm to make its way inside you. But it's a very low probability. Nonetheless, it is one. Page 6 of judgment contains the following finding. While she failed to provide records of any Planned Parenthood appointment, anonymous or under an alias, respondent presumably sought records from all Mission Viejo Planned Parenthoods, as that is where up until today, petitioner disclosed she sought care. This finding is not supported by any admitted evidence except by her own testimony.
Right? Like, which is evidence. But okay. Okay.
Page 6 of the judgment contains the following finding. The court was not provided with evidence of the positive COVID test, but maintains that the nature of her high-risk pregnancy would warrant a visit to the emergency room, who would be equipped to care for a high-risk pregnancy wherein the mother was COVID positive. Okay.
Okay.
Sounds good.
In 2020, okay. This is not okay. I could understand this was like in 2020. This is in 2023. Get out of here. Stop it. They have tons of things in place. So, okay.
This finding is not supported by admitted evidence and further reflects the court did not properly consider or weigh all of the admitted evidence. Specifically, the court assumed, without any basis for doing so, that visit to the emergency room was the only proper response to the events that occurred on July 23rd, 2023. There was no admitted medical testimony to support the speculative conclusion.
What are David's other proper responses to a person who thinks they're miscarrying? What are the other appropriate proper responses, David? Asking a telehealth person who told you, take your fucking ass to the emergency room. Like, what are you even saying? Oh my God. Ugh.
And the court's assertion further ignores the fact that Laura was considering terminating the pregnancy via medical abortion, in which case care for a high-risk pregnancy was entirely unnecessary. Then why is she trying to seek paternity? If that makes no fucking sense whatsoever. What?
And David, oh my God, first of all, even if she was considering having an abortion, the fact that she started miscarrying, allegedly, because this is your story, still makes it a medical emergency, because even with an abortion, you're still monitored because everything has to be gone and it's very dangerous no matter what reason is happening. Okay. Maybe you are not a reasonable person who knows how the female body works. Everybody else is a reasonable person, but you, David. What? What kind of? Oh.
Page 7 of the judgment contains the following finding.
Buffy, moving on.
Petitioner admitted to changing the HCG test result to reflect 31,000. This finding is not supported by any admitted evidence. What? Did she say she did? I'm so confused by what he thinks is evidence. You passed the bar twice. Testimony is evidence.
Yeah.
Okay.
And then you decide, whoever's deciding on the thing, what weight to give the evidence. Because just because something's evidence doesn't mean, you know.
And if you had a jury, like you're complaining you didn't have, they would be able to use that.
Right, exactly. You would tell them, listen to the testimony of my client. Listen to the testimony of my expert. Why would you say that, David? Why would you say that? Oh, I know. And I've passed the bar exam 0 times, twice.
Text packet. She says she altered the ultrasound in the deposition on the stand. I know. That's my point, is that she said it on the stand. So therefore it's admitted evidence. I don't understand why he's saying it's not admitted evidence.
I don't either.
Because page 7 of the judgment contains the following finding. October 16th, 2023, the petitioner's blood was drawn and the results were HCG levels of 102. Petitioner changed the results to reflect 102,000. The second sentence of this finding is not supported by any admitted evidence.
No. Is he like implying like there wasn't an expert to like?
Wait, are you serious? It was literally put on the screen for her to read.
It was. That's true. I do remember seeing that. Yeah.
Okay.
Say cheese. No way. No way. You went to kindergarten twice. My son went to kindergarten twice. It happens. Were you a summer baby, honey? Because that can sometimes, that was, my kid's problem.
I
He was a
mean, what
summer
it
baby.
may not have been an actual like exhibit, but it's testimony. Testimony is evidence.
That you can use to come to a conclusion. You can give whatever weight you want to whatever. But sure, David.
Otherwise, why have anybody on the stand talking at all if you can't make any decisions based off anything they say? Makes no sense.
Also, this is not making his client look good. These are things his
Oh.
client said.
Page 7 of the judgment contains the following finding. Upon denial of her request for mediation, however, she did not file a motion to dismiss or make other arrangements to advise respondent on the development of the development. This finding is not supported by any admitted evidence and is directly contrary to the undisputed facts. Ms. Owens, through counsel, filed a motion to dismiss with prejudice on December 28, 2023. Page 7 of the judgment contains the following finding. The court finds this testimony uncredible and a misuse of judicial resources.
Oh, really? Because it is. Because it is.
Uncredible is
trash,
not
Your
a
Honor.
word. Uncredible is not a word. And to the extent the misuse of judicial resources finding referred to the immediately preceding finding that Laura, she did not file a motion to dismiss or make other arrangements to advise respondent of the development. This finding is not supported by admitted evidence, and it ignores the fact that Ms. Owens could not advise respondent of the development because he blocked her. He blocked her ability to communicate with him. And moreover, respondent had sought and obtained an injunction against harassment, prohibiting Laura from communicating with him. Page 7 of the judgment contains the following finding. The court finds failure to seek in-person care for a high-risk pregnancy to be both unreasonable and uncreditable. Uncreditable is not a word. And to the extent the court found Laura's conduct to be unreasonable, that finding is not supported by admitted evidence and is based on an application of the incorrect legal standard. This was not a negligence case, and the reasonableness of Laura's healthcare decisions is not relevant to any fact at issue.
I disagree.
Page 7 of the judgment contains the following finding. The court further finds that going to Banner for a pregnancy test, but not the passage of fetal tissue, to be unreasonable and uncredible. A reasonable person, if seeking emergency room care to confirm a pregnancy, would not rely on telehealth to confirm the non-viability of the pregnancies. Uncreditable is not a word. And to the extent the court found Laura's conduct to be unreasonable, that finding is not supported by any admitted evidence. Did you just copy, cut, and paste?
Yes, absolutely.
And it's based on an application of the incorrect legal standard. This was not a negligence case, and the reasonableness of Laura's healthcare decisions is not relevant to any fact at issue.
Like, okay, it's supposed to be non-credible. Get over yourself, David. Shut up. It was not a word. Okay, who cares? You know what? People, oh my God, people piss me off when they're like that because it's like, oh, are you just not good at context clues then? Like it just threw you off because it wasn't said properly. Grow up, David. Grow up. You know damn well what they were trying to say. Shut up. Makes me mad. This is why you don't get invited to parties.
Page 9 of the judgment contains the following findings. The court finds Dr. Medchill's testimony that 0.1% chance that petitioner received a false positive due to several medications she is in fact taking, possible trigger shot for HCG, and a prior history of ovarian cancer to diminish his credibility, especially given that the records that the petitioner testified existed were not presented to her own expert for review and consideration. Diminish and creditability are not words. The finding that Laura had a prior history of ovarian cancer was not supported by any admitted evidence at trial. The finding that that records that the petitioner testified existed were not presented to her own expert for review and consideration, was not supported by any admitted evidence at trial.
Are we here to talk about laws or words? Like, what are we,
This
word school? Like, what are we doing
it's
here?
it's an English class.
This is why nobody wants to go to Top Golf and have nachos with you, because this right here is just, come on. You're wasting people's fucking time here. Stop the games, David. Stop the games. And as text packet put, apparently Google says uncredible is a word, but it's considered archaic and rarely used. Doesn't make it not a word, and there's nothing wrong with archaic words, but it means not able to be believed.
I live
Man,
with people that like
you're
to correct
you're
my words.
oh, I can't stand those fucking people. I can't do it. Like, I try to help people if they don't know the word, but then they're like, your whole argument's bad because you used the wrong word. Shut up. Who
No,
cares?
I'll say the wrong word all the time, and my daughter
Yeah.
go, "Really?" Like, and then they'll laugh
Right.
and correct. I'm like, you know what I meant. Like, do you need it to be the right word? Like, obviously,
Yeah.
clearly,
Do
you
you?
picked up the context clues.
To
Like, did you really need
understand?
it to fix?
No.
I understand if you didn't know what I was saying because I used the wrong word, but you clearly understood because you knew enough to correct me.
Exactly. Grow up. Hi, Nick. Heyo, sending invites to today's Slightly Buzz show via Sarah. Oh, thank you, Nick.
Well, she's starting early.
I am starting early. Oh no. Oh no. Last time I joined Nick, we were both very well buzzed. Yeah, I'll see if
Just
we
in time for an audio to be released or a video
right.
of
That's
a
what happened
court
last time.
hearing. I know. That's why I'm telling you it's going to play out the same way.
Yeah, Nick, I might stop in. That sounds awesome. So thank you. So go over there. I might be over there, chat. Well, we had a great time the last 2 times I was there. So anyway, these people drive me crazy because it's like this is why nobody wants to go to Top Golf with you. You don't need to point out. It doesn't make you sound smarter. It makes you sound more like a dick. And this is why you don't have any friends
That's
and you're not fun at
I think
parties.
that's the default for him.
I know. But I ain't coming to play Top Golf with you. I'll tell you that. You go on my list of like, no, thank you. No, thank you. All right, continue on. Let's hear more
Page,
words that aren't words from Greg
page
or
9.
David.
I would say not Greg. Greg's rolling his eyes at
I know.
this.
I know.
Page 9 of the judgment contains the following findings. Dr. Medchill testified that a blood HCG level of 102 is proof of a non-viable pregnancy, while Dr. Medchill testified that a non-viable pregnancy is still a pregnancy. The court finds that altering the number to reflect 102,000, which would be a viable pregnancy, to indicate that she intended for the respondent to believe that she was still pregnant with viable fetuses. The finding that Laura altered the HCG test to reflect 102,000 was not supported by any evidence admitted at trial. Bro, she said she changed it. She admitted
Right?
she did it.
What are
Now,
you
if you would argue that it wasn't for Clayton or to the courts, it was for Dave Neal, that you could put in there, but she said she changed it.
mm-hmm.
Page 9 of the judgment contains the following findings. Dr. Medchill concluded that the petitioner became pregnant on May 20th, 2023, and ended with a spontaneous abortion late October.
Oh. Mary, good
Early
luck with the
November.
smoke down there. Oh,
Or
you're in the middle of a
possibly-
move. Oh no, I'm sorry. Sorry. We're bonding.
Are possibly sooner in 2023. Given the alterations of the only records to indicate pregnancy, the court does not accept this conclusion. The finding that Laura altered the only records to indicate pregnancy misstates the evidence and was not supported by any admitted evidence at trial. Okay. Page 10. You have way too much time, bro.
And speaking of words, just real quick, because Berkeley's like, I have a degree in English and I like big words and cannot lie. But nitpicking makes you look like a jerk. You know who else loves words? Jack Fox. You know who's not a dick? Jack Fox. All right. Whose entire channel is all about the words we use. And guess what? He's not a dick about it. I'm just saying. He is a proper gentleman. I love Nick. I'm sorry. Well, I love Nick Sorrow as well, but I love Jack Fox as well. So see, you can do that and just not you want to educate people, right? Not, but you all know who I'm talking about. Those kind of you're not that kind of person, Berkeley. I know. Right, Jack is amazing. He's super fun, guys. And so incredibly nice. But anyway, continue on. Sorry,
I
Beth.
don't even remember where I was.
The judgment contains
The judgment contains the following findings. The court does not accept that 24-week-old twin fetuses would be reabsorbed. Science doesn't accept that either, okay? Into a mother's body. The court further finds a miscarriage at that stage of pregnancy would result in emergency medical care and corresponding death certificates of the twins. If what Dr. Mitchell testified to is true, and she miscarried much sooner, negating the need for death certificates, then petitioner perjured herself at a prior hearing. No aspect of the above finding was supported by any evidence at trial.
what? What? Okay. Okay. Ugh. David. But okay.
He literally said, "Nuh-uh, we didn't say
Nuh-uh.
that."
Nuh-uh. Only can you not use the right words, but nuh-uh.
I
Oh my
didn't do
God.
that. We didn't say that. I didn't say that. What are you
And if
hearing
she
me?
said it, it wasn't evidence, so you can't even take it into consideration. Don't listen to what she said. It's fine. And she shouldn't get in trouble because it's not evidence.
I think he's doing this on purpose to confuse
Like, here's the thing.
people.
If testimony isn't considered a form of evidence, then why do you got to take an oath in the first place then? If it holds no value to whoever is saying that, it doesn't even make any sense.
Well, that's what I said earlier. I said,
Mhm.
that why does anybody ever get on the stand to talk at all? It would just be
Exactly.
paperwork.
Exactly. Why, David? Why? Don't worry. I'm sure there's a blog post about it somewhere. Oh, we still have so many of his blogs to go through.
Page 10 of the judgment contains the following finding regarding the testimony of Dr. Deans. She further testified that Planned Parenthood is not open on Sundays. When petitioner testified, she sought care July 2nd, 2023. This statement was not supported by any admitted evidence at trial. Page 10 of the judgment contains the following findings. After reviewing the records, Dr. Deans determined that HCG tests were never dispositive of pregnancy and that the related miscarriage timeline, which included detailed analysis of the likely origin of HCG in petitioner's blood and urine, was not indicative of human gestational norms. Emphasis on in original. No part of this finding was supported by any admitted evidence at trial. Page 10 of this judgment contains the following finding. Petitioner has a prior history of ovarian cancer that prompted the surgical removal of her right ovary. No part of this finding was supported by any admitted evidence at trial.
Oh my
Okay.
God. So you can't get charged with perjury if there's no evidence. I mean, it's fine. There's no evidence proving which one's the lie is basically what I feel like he's saying. Like, well, I don't know.
Well, I
They
mean,
both-
isn't that
They both are.
kind of how it works? Aren't you supposed to prove the lie? But I feel like some of the stuff he's saying didn't happen, did happen, and she said it on the statement. That's the part I can't get past. I mean, I agree. You have to prove the lie, but you said it on the stand. Oh my God. Okay. So page 12 of the judgment contains the following findings. Petitioner provided respondent with a sonogram that was posted on YouTube 7 years ago. Petitioner admitted to this during her deposition. Okay. As to the finding that petitioner admitted to this during her deposition, no part of this finding was supported by any admitted evidence at trial.
You know who greatly disagrees with David Gingras about this? The Maricopa County Prosecutor's Office. That's who. Apparently it was enough for them and they didn't have any of the evidence, just her words for perjury. Wild how they came to this conclusion, but okay, David.
Page 17 of the judgment contains the following findings. The court further finds that petitioner repetitively failed to comply with Rule 49, even on order of this court. No part of this finding was supported by any admitted evidence at trial. Furthermore, the court seems to have completely misunderstood and or misrepresented Rule 49 as requiring Laura to somehow predict information sought by Clayton and then disclose that information without Clayton ever asking for it. In this regard, the court's interpretation of Rule 49 was plainly erroneous as a matter of law. Nothing in Rule 49 required Laura to disclose any information about the names of doctors she had. What? I feel like I really remember reading those motions where it was like repeatedly emails to and everything. Like, that's weird.
Oh, yes.
Okay.
But it wasn't at the trial, so it doesn't count, though. But
Okay, but it's all in the paperwork. Okay. In this regard, the court's interpretation of Rule 49 was plainly erroneous as a matter of law. Nothing in Rule 49 required Laura to disclose any information about the names of doctors she had seen or medical records of any kind. Clayton wanted such information. He could have served interrogatories under Rule 60 or document requests under Rule 62, which asked for this information. Clayton did not do so. Instead, he simply took the position baselessly, that baselessly is not a word, Buffy. Baselessly. That Rule 49 required the automatic disclosure of any and everything Clayton believed was relevant, even if the information was not within any part of Rule 49's disclosure requirements. Okay. In addition, Clayton's motion to compel was filed on March 10th, 2024. And in that pleading, he argued Laura had willfully and wantonly failed to disclose information pursuant to Rule 49. Clayton's arguments were directly contrary to the minute entry order issued in this case on February 21st, 2024, in which court stated it is further ordered the parties shall complete initial disclosure no later than 45 days from today's date.
Oh, text packet has looked up the rule, by the way, that he's just talking about there, which just gives the parties have to disclose the names, addresses, and telephone numbers of any of the doctors or therapists, I almost said terrorists, they intend to call as witnesses at the trial. Sorry, I'm trying to get some crackers and stuff. So thanks, text packet, for that.
Despite this, Clayton's motion to compel was filed nearly a month before Laura's Rule 49 disclosures were even due, and the motion to compel further falsely stated that Laura had no previous. Wait, there's an error.
Uh-oh, everybody get ready to write a 32-page motion on the errors of David's motion, because they're very serious.
You're missing the T and had not previously made any disclosures at all under Rule 49, a point which is 100% factually false. The finding that Laura repetitively failed to comply with Rule 49 was plainly erroneous, and the court's finding in this request was directly contrary to law. That was a lot of words, David. Page 18 of the judgment contains the following findings. The court, having determined that Laura Owens has a pattern of similar, if not identical, behavior and court involvement, ... No part of this finding was supported by any admitted evidence at trial. Additional relief requested. Pursuant to Family Law 85, Laura further requests that oh my God, another error. Look, even you're tired of writing so much, you keep leaving letters out. The following prior orders be vacated.
But he needs more pages, though, Buffy.
For what? January 25th, 2024, order granting Clayton's motion for leave to amend. February 14th, 2024, order denying Laura's motion to dismiss. April 3rd, 2024, order denying Laura's request for extension of time to respond to Clayton's motion to compel. April 9th, order granting Clayton's motion to compel. May 1st, order denying Laura's motion to compel lunch. Really? May 22nd, 2024, or order denying Laura's motion to strike and motion in limine. And May 29th, 2024, order denying Laura's motion for judgment on the pleadings. First, many of the trial court's orders granted relief in favor of Clayton. That's not fair. His request for leave to amend and his motion to compel. But in substantially every instance, Clayton's counsel, Greg Woodnick, filed those motions without making any attempt to meet. He's still butthurt about lunch and confer as required by Family Law Rule 9. Compliance with that rule is not optional, but Mr. Woodnick repeatedly ignored it without any basis. Mr. Woodnick further filed a motion to compel which did not contain the good faith consultation certificate required by Rule 65. And incredibly, the motion to compel did not ask for an order requiring Laura to respond to any specific discovery request because no discovery request had been made regarding the information sought in the motion. Incredibly, the motion to compel was solely based on Laura's alleged failure to disclose under Rule 49.
Did he
But
use
the
the same word
information-
twice in the same paragraph? Maybe you should get a thesaurus, David.
I'm really, really, really shocked. I think his T button is broken on his keyboard because he's left it off again.
Oh.
Like, yeah. Yeah. But the information was sought. I think it's sought, but there's no T. Records from the third part. No, his T works. Third has a T. So you're just, okay. Don't know how to prove. Did you even hit the spell check button?
No, he doesn't backspace, Buffy. That was your theory, and I think it's correct.
Yeah, it's probably true. Was not subject to any aspect of Rule 49's disclosure requirements. As noted above, the motion compel also contained knowingly false and fraudulent statements of facts and omissions, including 1. A statement falsely claiming Laura had willfully and wantonly failed to disclose information pursuant to Rule 49. And 2, an intentional deceptive omission which failed to remind the court that per the court's minute entry order issued February 21st, 2024, Laura's initial Rule 49 disclosures were not due until nearly a month after the motion to compel was filed. These knowingly false representations and omissions by Clayton's counsel constitute fraud sufficient to entitle Laura to relief pursuant to Rules 85B.
Fraud.
In short, assuming this matter is assigned to a new judge, all orders issued in this case by the prior judge should be vacated on the basis that they were issued improperly, without factual or legal basis, often in direct disregard for the rules of procedure by a judge with not only significant bias, but strong personal animus towards a party, which was unfortunately not possible to prove until just days ago. But you have
Clearly, she had it out for Laura, guys.
But she didn't prove anything. You just made a
Exactly.
lot of statements. Finally,
You had the most
pursuant to-
time. Well, that too. They had the most time in the trial. And you're going to sit here and say you had an unfair trial. Get out of here. Come on.
Finally, pursuant to family law, Rule 35A, Loris respectfully requests leave to exceed the 17-page limit of that rule. Good cause exists to submit a longer brief due to the large number of errors and issues discussed above. This is particularly true because as a matter of law, Laura cannot raise arguments for the first time on appeal, and most, though not all, of the problems described above occurred in such a manner, post-trial, that Laura had no prior opportunity to present and preserve these objections. For the reasons stated above, Laura respectfully requests after you just shat all over the judge.
Who's reading it?
Order vacating the June 17th, 2024 judgment in its entirety, granting additional relief as requested above, and order a new trial before a new judge.
Pretty please. Pretty please. Oh my God. I'm so glad that's over. Oh, jeez.
Yeah.
David, don't worry. We don't have long ones from David for a while.
I am dumber having read all of them. And his good faith certificate is attached because he feels like if you don't, then everything is null and void.
Well, he's going to file a motion if you don't, because remember he did with where's the good faith certificate, guys? Blah, 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 blah. Well, that's dumb. All right, I'm sorry, but yes, did the judge make some mistakes in her writing? Sure, but then to sit there and say that all of his clients' testimony doesn't matter because there wasn't evidence, it's very hard to take you seriously, David, on the hills you want to die on. Very, very difficult. Because reasonable people are looking at this case. I know David like has it out for JFC and the cult, but believe it or not, it is a lot of people who are not fans of Clayton Echard. I'm not a fan of Clayton. I don't dislike Clayton, but I'm not like a bachelor fan of Clayton. No, we're reasonable people who read all the things and realize your client is a liar who lies. And the Maricopa County Court seems to think so as well at this moment, or the prosecutor's office, I mean. And we'll find out when she does, in fact, probably, most likely, go in front of a jury. So well. Oh my goodness.
I mean, I will literally give everybody the benefit of the doubt to the very end. I gave her so much at the beginning that even the chat was very disappointed in my grace. But yeah, no.
Well, I mean, that's just how it goes, right? Like the more you find out is when you should start making your decisions. Like we talked yesterday for several hours actually about the upcoming Murdaugh trial, right? And I have my opinions from the first Murdaugh trial. And I said going into the second trial, like I am going to keep an open mind and we'll see if it changes my perspective of the first trial and why I feel the way I do. Because that is something we like to do here, right? Like, are there some things we're biased at? Yeah, when Laura goes to trial, I'm going to be biased AF. Okay, I am. I'm just going to preface that. But also, though, if the state does not do a job proving their case, I have no problems or issues saying no, not guilty, because the burden is
I do
on.
believe they're guilty. Like, even if I
Mhm.
do believe that person did it because I have just those vibes, I look at it solely, did the state do its job? And even if I
Absolutely.
already believe it, if you didn't give enough to like back up my own beliefs, like I still won't. Still won't.
Right? Most of us I've never watched The Bachelor. I do
No,
not
it's not.
care that Clayton is arguably famous, according to David.
It's not
I
my
don't
thing.
care. I don't care.
Not my
Uh,
thing.
now, Wendy asked, is anybody going to watch the Lindsay Clancy trial when they get the jury together? Listen, I would love to. And Spencer, hi Spencer, I didn't get to say hi to you, said that they're going to be definitely watching the trial. This trial would lead to many interesting discussions on mental health and culpability. Absolutely. It's a very important trial that is coming up. It's wild. We were talking about this with Mo yesterday when she was on, that this case is very reminiscent of the Andrea Yates trial. She had two, mind you. The first guilty, the first not guilty by reason of insanity due to postpartum psychosis. It's a very important topic. And even though we've known and explored the idea of postpartum psychosis, it's still something that a lot of people have a hard time comprehending, right? Because how could you do what you did and take away your children from this world? But it's a very, very real thing. There is lots of discussions to be had, and maybe we might have some on our True Crime and Wine Time show about it. I will not be covering that trial for a few different reasons. I think it's a very important trial. I need people to watch it and to pay attention. But one, it's a 6-week trial. I've covered 6 weeks trials. They're exhausting to sit there like it requires so much from you to sit every day and cover a 6-week trial. It's exhausting. Two, I can't because my son is starting high school. There's a lot of stuff in the month of August we have to prepare him for. And I can't when I cover because I covered trials for like a whole year. And it's so exhausting, right? Because you're basically like improving the entire time. because you never know what's going to show up in court. And it's mentally exhausting that like I couldn't be there for my family, let alone 6 weeks of it. Um, and then third, I really try not to do kids' trials because regardless of how I feel about the mental health aspect, the postpartum psychosis, I don't handle kids' cases very well. So I try not to cover them at all when I can. And unfortunately, I I can't. I can't do this. I can't do this trial. But it is very important. I am going to be keeping an eye on it, but I can't dedicate, 8 to 10 hours a day of what is truly going to be one of the most tragic trials, both for the children, both for Lindsay, for the family, so it's going to be a very, very tough trial to watch. And I hope people do watch it. And I hope people do have the conversations that need to be had because postpartum psychosis, postpartum depression are very real, very, very real. And the more we talk about it and acknowledge its reality, hopefully we can save mothers and their children in the future because these are not one off situations. Terry True Crime has a whole ass show called Dearest Mother's Darkest Secrets, and the majority of those cases are from postpartum psychosis or depression. So I know there are people that are planning on covering it. Those are the reasons why I can't. Like I said, I might pay attention to like what's being said about each day, and maybe Terry and I will talk about it. But I know my limits. I've been watching trials for a real long time. So, it's very important. So if you do have time to watch it, if you don't know much about it, please do go and, listen to it and listen to what's being said. Because it's very real. And I also know this is not just somebody, people's takes on the insanity defense are very frustrating. It's very hard to be able to use an insanity defense. It's very, very hard. The bar is very high. The judge has to approve it. You can't just say, "Oh, do do do." But she was trying to get help for a very long time, and you're probably going to listen to it and see that the system failed her. Um, but it's very important. It's very controversial and upsetting to hear the people arguing for sure. It is, and I get it, right? You can't be mad at people who aren't educated on a subject matter. And we don't see enough of these trials of women who suffer from that and unfortunately take the lives of their children or themselves. Um, but it's very, very real. So I'll be paying attention in like the background and maybe we'll cover it on a true crime and wine time or something, but I can't unfortunately dedicate the proper amount of time and brain power needed to discuss this trial the way that it deserves to be discussed. I know my limits, so you know there'll be I am sure some of the law tubers are covering it because it's a big case. Um, we really haven't seen one like this since Andrea Yates. And how many people are still unfamiliar with the Andrea Yates, whether they were around or not, right? That second trial she had, which was the not guilty for by reasons of insanity, like a lot more information was able to come out that you're like, okay, this is something else. And Andrea, here's the thing. Andrea's been locked up in a mental health hospital since then. She is eligible for parole. And if she asked the state, they probably grant it to her, quite frankly. But she has no desire to leave there. You know, to say that Andrea, from everything I've heard of her in her own words, she doesn't not ever want to be in a position where that could happen again, even though she's an older woman now and it's unlikely, but So I hope y'all do watch it. And remember, it's okay to take breaks from trials that are that heavy. You can always catch up. I know people do recaps, things like that. But I mean, the last big, there were kids involved in the Canaro one, which those were hard days. Buffy can tell you those medical examiner days. I was fucked up. I'm glad we had a few days off in between that testimony and the next one, because even the judge gave the jurors a day off. Like, okay, you're gonna need a break. But it's very interesting. Plus, it's in Massachusetts, so there's that. But yeah, I won't be doing that at all. So, oh, yeah, sorry, this one. Um, the subject matter is very, very, very important. Very, very, very important. And I'm sure I'll talk about it sometime, but no. 6 weeks of that? Mm-mm, no way. I won't have shows for the rest of the year if that's the case, I'll tell you that. So, yeah, I'm more than happy to talk about the Lindsay Clancy case. We've been talking about it for years, you know, but I've been there, I've done that, and there are better people that I think can talk about it than me. So, and who can handle it better than I can. So, um, but anyway, so that is all we have for you today in the world of Laura Owens. Now, if by some miracle I have cookie or cracker crumbs all over my desk now, if the bankruptcy mock thing comes out, the hearing, then you might see Buffy and I this weekend. We'll definitely go live for that win this weekend. You'll have to turn on your notification bell to find out so you don't miss us if we go live. Oh, don't even get me started on Rusty. I don't know much about Lindsay's husband. I hope he's not a Rusty. I don't think he's a Rusty, but fuck Rusty Yates. All right. Fuck that guy. Mm. I have strong opinions about him. But anyway, so we'll be doing that if that comes out. I'm probably going to go hang out with Nick Starro tonight. I know Amos made it so this stream will redirect to his channel to that video, so you can hit the notify button when it goes live if I go over there tonight. And then next Tuesday and Thursday, we're watching Bam, Bricks and Minifig stuff again. And then we'll be back next Friday with Laura Owens stuff. Obviously, unless that mocks, it's subject to change depending what comes out. But otherwise, that's our schedule for next week. I'd rather stick to the ridiculous stories like the Owens family. I mean, this is quite a deviation from what we normally cover on this trial. We usually don't do civil stuff, or it's mostly very horrible, sad stuff. But those stories need to be told too. So this actually was after I got done with the Paul Canaro trial. I was like, we're doing this. I cannot sit for another trial for 6 weeks. I can't do it. So yeah, F Rusty. Rusty sucks. And people need to see the system, right? Because everyone's like, oh, well, why didn't you just go get help? Well, you're about to find out. I'm telling you, it's going to be brought up in the trial. The reality of the mental health system in America. And it's going to make you pissed and it's going to make you outraged, but it's real. Insurance doesn't give a fuck. All right. And they will put the burden on the whole family. Now, there are other things to argue about that when it happens, but it's a real eye opener, right? Because people are like, well, why didn't they just go get help? Why didn't they just go get medicated? It's not
Because
that
there
difficult.
isn't any place to go get medicated. You know how
There
long
may
it
not be
takes
a
to get
place.
in?
It takes a
There
long
isn't.
time
I
to
had to
get.
drive my child to Texas to get her help.
Mm-hmm.
Yeah. And then they wanted to send her home after like a week. And I was like, no. And then I fought with insurance to let her go. Yeah. If she was
Mm-hmm.
very, very sick.
And there is that
Not her
if
fault.
medicine was so easy to like fix problems, we wouldn't have the crisis we have. But it's not like that. It is so much trial and error, so many and sometimes the people are just medicine resistant. There's literally nothing you can do. And I feel like that's, you hear everybody, I'm a mental health advocate. I'm a mental health advocate, blah, blah, blah. But like, there's a reality about the system, and nobody wants to talk about that. And that is,
Mhm.
we don't have much of one. And
Yes.
people that are very unwell don't have very many options. And when we have a system that is broken, when it's due to insurance and money and things like that, people lose their lives, whether it's adults, whether it's children. People are losing their lives every day. So I can guarantee you this trial is going to point out all the flaws of the system, and they're not going to be wrong about it. Now, whether or not that's related to Lindsay's scenario, up for a jury to decide. But whatever they say, and they're going to talk about it, that's the reality of it. Um, so yeah, Stalk, that was the one that did me in. And I was like, nope, never again. I wasn't even streaming that one. I was just watching it. And I was like, no, I can not.
I think
Murdaugh
I'm
was very
broken.
long.
It doesn't bother me.
We're probably gonna start covering the Murdaugh since it's getting a new trial, because I have some very unpopular opinions. And I am very interested in the second trial and how both sides are gonna handle the second trial, particularly after the Karen Reed trial. Because in Murdaugh, they used some of the similar evidence, if you will, that then we learned in the Karen Reed trial may not be as reliable as they think. So I think we're going to start following that on like our True Crime and Wine Time show. And then when it comes to trial time, we'll probably watch it on Couch Court with Llama. But I'm probably going to definitely be covering that again, because I have tons of questions. I'll say this. One, and this is going to get so many comments in the chat. One, I don't think he killed his family. I don't think he killed his wife and kids. Do I think he was there? Yes. I don't think it was him. Therefore, that's called reasonable doubt. Two, the prosecution left me with a lot of reasonable doubt. But who knows how they'll do this? Like, I'm going in with an open mind. Maybe they'll do a better job. And that's a much longer opinion to share with all you guys that I'm not going to do now, because we've been here for a long time. Peachy says, preach. I teach special education in rural areas. Yes. And let me tell you, I have 6-year-olds on waiting lists for the rural areas are, it's devastating. It's devastating. People need to be more realistic of what's really fucking out there. You live in a big city, yeah, you can probably find help better than other people, but even then, it's tough in a big city. Rural areas, might as well fucking forget about it. It doesn't even exist around there. So, and PGT teach, good for you for your job. It's very, very important. Most people won't go to the rural area because they don't make as much money, but those kids there definitely much need your help. I think the distinction between Lindsay and Andrea is that Lindsay tried to get help. Andrea was under Rusty's influence, but they were resistant. No, they weren't. That's absolutely not true, Spencer. I'm sorry. No, Andrea was institutionalized several times, even up weeks before she murdered her children. She was institutionalized, and they were kicked out because of Rusty's insurance from fucking NASA. Let alone the new doc wanted to change up her medicine and not continue the medicine that she was used to having, that she thought did help her. Andrea Yates has a long history of mental health issues being institutionalized, not being the main problem was the system. Rusty did not help in the sense that he treated Andrea as a baby making factory, because the doctors told Andrea it would be dangerous for her to get pregnant again, because she already had a history of postpartum psychosis with her other children, and that it would be extremely dangerous to do so. And Rusty, being the fucking piece of shit he is, didn't care and got her pregnant again. Rusty is a bad guy in this situation too. But unfortunately, we cannot put all the blame on Rusty. We have to put the blame on the system, because Andrea was looking for help. Was she in this weird cult like religion with Rusty? Yes. But did they try to get actual help? Absolutely. Absolutely. And that's what's so there we are. We've switched places apparently. Um, and so that's why it's just like so important to talk about. And by the way, I was not yelling at you. I apologize. By the way, please don't come across. I'm very passionate about it, and nothing you said is any of that. But anyway, friends, we're gonna get off of here so I can at least take a break. Yeah, I live in a capital city with numerous hospitals too, and good fucking luck. Good luck. So, all right, friends. Well, thanks so much for being with us today. I know it was interesting. But don't forget, while we're all depressed talking about really sad real stuff, some exciting real stuff is that I'm wearing Omar's tie and it still smells delicious. That can cure your mood for sure. So, all right, friends. As we said, we hope you have a wonderful weekend. We'll be back this weekend if something pops off with Laura Owens. Otherwise, we'll be back Tuesday, possibly again, depending to what happens. So, all right, friends. Thank you so much, Buffy. Anything you want to say before I end the stream? No. All right. Until next time, friends, go forth and be amazing. All right. Bye, guys.